Good evening, everyone. My name is Tom Congdon. I'm the Executive Deputy at the New York State Department of Public Service and the Chair of the New York State Decommissioning Oversight Board. I want to welcome you all to tonight's public forum. Before we dive in and I introduce the panel, I just want to go through a brief introduction about what the Decommissioning Oversight Board is and what we've been doing. Next slide, please. The DOB provides a venue for information exchange, oversight coordination, and public engagement. Our goal is to ensure the safe, prompt, and thorough decommissioning of Indian Point. These were the key public interest drivers that caused a number of stakeholders, including the county, town, village, riverkeeper, Public Utility Law Project, Hendrick Hudson School District, the Attorney General's Office, Entergy, and Holtec to agree to several terms of a joint proposal that governed the sale of Indian Point from Entergy to Holtec. That joint proposal, signed by all of the intervening parties in that proceeding, included a number of important public interest conditions that were then approved by the Public Service Commission. The Decommissioning Oversight Board was created shortly after the sale to Holtec was complete and decommissioning commenced. Our hallmark in our meetings is that we are attentive to community perspectives. All questions are responded to, and when the facts through that information exchange show gaps, we seek to fill them. Next slide. So the DOB, as I said, started shortly after the sale to Holtec and shortly after the second reactor closed. Our first meeting was on June 23rd, 2021, and since that time we've held 12 meetings, 11 of which included a public statement hearing or was solely dedicated to a public statement hearing. The DOB has held 2 public forums dedicated solely to answering questions from the community and 1 standalone public statement hearing, as I mentioned. Tonight is the 3rd public forum. In addition, there have been approximately 200 questions that we have responded to in writing that we put on the DOB website. And that doesn't include the questions that were submitted as part of this public forum. We're going to get to as many of those questions as we have time for. But as in the past, we will endeavor to answer all of the questions that were submitted and post those answers in writing in the coming weeks to our website. Next slide. So as I said, our hallmark is really that, through this information exchange, having our meetings publicly, having the regulatory agencies talk about our work in a transparent way, and then giving opportunity for the public through public statement hearings and public forums, is to really have a feedback loop and talk and engage with the community and try to be responsive to the community interests. Just to list a few things that have come about really from that stakeholder involvement, there was a desire to move up the number of meetings that we were having from roughly 3 a year to now just about every other month. We've improved our hybrid meeting platform. Many of you have been at this with us for many of the meetings, know that we had a number of technical glitches with earlier platforms, and we've really focused on improving that process. We've overhauled our website to improve navigability. There is a wealth of information on our website. All the documents, regulatory documents, correspondence, all of the meetings that we've held. There are both meeting transcripts and video archives of all of our previous meetings and public forums. We were also listening to the public when we changed the format to invite from time to time community guest speakers, and as well as bring in our federal agency partners to regularly present. To date, we've had a number of guest presentations, a leading member of the community, Courtney Williams, another leading member of the community, Tina Volz-Bongar, Michelle Lee, Dr. Catherine Falvo, Richard Kuprowitz, an independent pipeline expert, the Nuclear Regulatory Commission, of course, the EPA, the Pipeline Hazardous Materials Safety Administration, and the Department of Energy have all been guest presenters from previous meetings. We also certainly want Holtec, and from time to time the owner of the pipeline, to also come before us, give us updates from their points of view. The activities that go on with Holtec have been really a critical piece of these meetings. Having Holtec here answering the questions of our Decommissioning Oversight Board members, the regulatory agency, I think has been incredibly important as part of our oversight function, but also in the information sharing that is so important to us. Next slide. So again, through the information exchange, we have identified gaps that we felt were important for the state to step in and fill where we could, and where the federal government wasn't able to or wasn't filling. So, as I said, when the Public Service Commission originally approved the sale from Entergy to Holtec, we were able to include a number of public interest conditions, some of which will be discussed later in the public forum. For example, we required financial assurances protecting the decommissioning trust fund. We required specific timeframes by which they had to move the spent fuel to dry cask storage, and other key public interest provisions. We have discussed issues that merited state agency submission of comments to the Nuclear Regulatory Commission. For example, Holtec has requested a number of license exemptions that they believe apply to a decommissioning site. Many of the regulations, they have argued, really are only applicable to an operating nuclear plant, so they've submitted requests for exemptions. The state has submitted comments opposing those license exemptions. The NRC has to date not acted on those. Also, the NRC pulls their resident inspectors from a power plant when it ceases operations. This is to reflect the reduced risk at the site, which we agree the risk has reduced at the site. But that was a concern that was clearly articulated by residents in the community, that having no resident inspector on site on a day-to-day basis seemed to prevent or seemed to create a new gap in regulatory oversight. The state then stepped in and hired a resident inspector that works out of Holtec offices, is on site daily. And so that's eyes and ears that the state now has on the operations of decommissioning. And to the extent there are issues raised, they can raise them to relevant regulatory jurisdictions, whether that be the NRC, or the DEC, or the state. A huge issue early on in our work as a DOB was in acknowledging the co-location of gas pipelines near the Indian Point site. There was a lot of controversy around the siting of a new pipeline. There were pipelines that were long in existence that do crisscross the facility. And so the state had raised some concern about when decommissioning commences, that there needed to be good protocols established to ensure the safety and integrity of those pipelines. And you get that through a number of things, including physical protections of the pipeline that protect the pipe from heavy load crossings, and strong inter-corporate communications between the owners of those facilities. And we established a memorandum of understanding that guides those communications between the companies so that they're regularly meeting, discussing each other's operations. And we at the Department of Public Service actually convene quarterly meetings of Holtec and of Enbridge to ensure that that communication is regular and thorough. Another concern raised through these meetings has been the migration of potential dust that could come from the site, especially during heavy demolition, which really has not yet commenced, but really any of the decommissioning activities that could generate dust. When we considered the issues associated with that, first of all, NRC rules prohibit dust leaving the site, but to the extent that there's not eyes and ears on the site 24/7, having our resident inspector was a key provision that helps to ensure that that remains the case. But secondly, there's actually a local regulatory role. And the village is a member of the Decommissioning Oversight Board. They actually have to issue building permits for construction or demolition of buildings in the village. That includes on the site of Indian Point. So also, Department of Environmental Conservation, which is another member of the DOB, has regulations that guide the public nuisance that's created by dust and other types of activities at facilities like a cleanup site. So we requested two of the members of the DOB, and again, one of the roles of the DOB is to have the different entities coordinate and communicate their various roles and responsibilities. But by having that issue raised by the public at these meetings and then discussing what we could do differently in terms of the village's role in coordination with the state DEC role, we fold the DEC regulations into the village demolition permitting process so that there's now a dust migration program that is incorporated right into the regulations at the local level. So in addition to the federal level, in addition to the state having a resident inspector, and then having the building demolition permit wrap in those conditions, that was important. And then last example here is the concerns of the nearby school. The BV Elementary School is about 4,000 feet away from the plant. Parents in the community and community members at large expressed concern about how decommissioning activities might have an effect on the school, and frankly, whether the operation of the nuclear power plant historically has already had an impact on the school. So two things are underway to address those concerns. One is a community air monitoring plan is being developed through contract with an outside entity contracted with the Department of Public Service that's going to establish the community air monitoring plan, and also an environmental assessment of current environmental conditions at the school, where the state provided a $500,000 grant to the school district to hire their own consultant to come in and do that environmental assessment at the school. So both of those work streams are now underway. Next slide, please. So now I want to move on to get into the public forum. Just like we've done in our previous public forums, we reached out and requested to the public through meeting notice questionnaires to submit questions in advance so that we could pull the right subject matter experts together to answer those questions. We've done so, and we're really pleased to have with us today a number of subject matter experts based on the questions that were submitted. With us, we have Bruce Watson, the Special Assistant, Division of Decommissioning, Uranium Recovery, and Waste Programs of the NRC. Paul Crone, Director, Division of Radiological Safety and Security, NRC. Tony Dimitriadis, Branch Chief, Decommissioning, Asphyxia and Reactor HP Branch, NRC. Rick Ruvo, Director of Air and Radiation Division, Region 2, EPA. Lisa Burianic, Deputy Bureau Chief of the Environmental Protection Bureau of the Attorney General's Office. Josh Talent, an Assistant Attorney General at the OAG. Rachel Adler, Project Coordinator of Workforce Development, Department of Labor. Alex Damiani, Director of the Bureau of Environmental Radiation Protection at Department of Health, State Department of Health. And Susan Spear, the Deputy Commissioner, Department of Emergency Services, Westchester County. Virtually, we have a number of folks with us as well. Lynn Jennings, Supervisor, Water Permits Branch, Region 1, EPA. Virginia Wong, Supervisor, Clean Water Regulatory Branch, Region 2, EPA. Christine Ash, Acting Deputy Director, Water Division, Region 2, EPA. And a number of state agency representatives as well. So, general logistics. In-person panelists, please remember to use your mic. That is the way that the folks who are watching us virtually can hear you, and the folks in the room through our speaker system. Panelists joining by Zoom, please keep your mics muted unless speaking. For the Zoom participants, please reserve the chat feature for reporting technical issues. Only questions captured in the Q&A field are able to be saved for review. And I mentioned before, we've responded to questions. Some of those questions come through this Q&A function. So to the extent you're watching virtually, The discussion triggers a question. Put it in the Q&A. We document that. We give it to our subject matter experts, and that gets posted with our responses to other questions we get in the way of public comment. Virtual participants are encouraged to use custom video layout features to enhance the view of speakers and presentation content. Go to support.zoom.us to learn how. All panelists and participants indicate your name before speaking. Next slide. So we've taken all the questions, we've organized them by topic area. The pre-submitted questions will be read aloud for the panelists to respond. We're joined by an administrative law judge from the Department of Public Service, Anthony Belcito, sitting behind me. Anthony has the slide deck controls with the questions. He'll call up the questioner, read their question, and then the questioner can stay at the mic to ask a follow-up question to the expert panel. In order to afford all individuals an opportunity for questions to be heard, Tony may ask that some discussions be paused until future meetings. Time permitting, additional questions will be addressed. The public forum will conclude at 9 p.m. tonight. Questions not addressed during the meeting will be answered in writing. That includes all the questions that were submitted prior to tonight's forum. Some individuals submitted a lot of questions. And we will endeavor to answer all of them, as I said earlier. And some individuals asked a lot of questions, some individuals just posed the one question. Every individual that submitted questions, we intend to call up to the mic, time permitting. We've organized the questions by topic area, so some of the questioners may get called up to the mic multiple times. And roughly speaking, if questioners posed more than 2 or 3 questions, we are endeavoring to get to roughly the same percentage of the questions from every speaker, from every questioner. So someone that submitted 100 questions, you'll see tonight at the mic more than others. But we believe that some of those questioners with the long list of questions are actually representing questions that many of you have in the audience. And so even though it may look like one individual, we believe we're being responsive to a larger number of people represented by that questioner. And we are tracking the questions we get in public comment and the issues that we see. So we have a pretty good feel for how to address that. Next slide. So as you can see, there are a wide range of issues in how we're organizing the questions, ranging from how the DOB is administered to workforce issues to the joint proposal. The joint proposal is the agreement I alluded to before that guides Holtec operations under the PSC order approving the sale of the plant to Holtec. Water discharge issues, of course, is a major topic of late. The regulatory standards that are governing the issues at Indian Point, dry cask storage, biological and health studies, emergency preparedness, and the gas pipelines. Next slide, please. So at this point, I will turn it over to Tony, who will be calling up the questioners, again with posing the question, and one of us on the panel will field the questions.
Thank you, Tom. I'll just remind everybody that we're here to answer questions and get as many questions answered as possible. So during follow-up, if folks start to offer more of an opinion or a statement rather than asking a question, I will encourage you to try to get to that question quickly, again, so we can get as many answered as possible. So the first set of questions are administration. We have for questioners, Courtney Williams, I believe is in-house, and Susanna Glidden, who's virtual. First question, why are you running the DOB in an authoritarian, undemocratic way, shutting out public influence, not heeding our request for independent safety, health, and emergency preparedness experts, not heeding our request for a frontline community representative on the DOB, and an open chat during meetings? And the second question, can Dave Lockbaum prepare a takedown presentation of Holtec's dry casks like he did for water tanks? or does he only see flaws when they suit his opinions? And will there be a discussion of hardened on-site storage? Susanna Glidden is on the line. Oh, I'm sorry, we're going to go to the question answers first.
I want to invite Courtney Williams to the mic if she's here.
She's not here.
Okay, so we'll go ahead and answer the questions. First, on the DOB administration question, as chair of the DOB, I'll take that. Obviously, I respectfully disagree with the assessment that we're running this in an authoritarian manner. I think the evidence speaks for itself. I just walked through a number of slides with evidence of the things that we've done over our first 12 meetings and actions we've taken outside of those meetings that really are responsive to the public engagement and feedback that we receive. Our DOB has literally every level of elected officials in the state of New York, from the village mayor to the town supervisor, to the school district superintendent, to the state senator and assembly member, county legislators, and the county represented. So the democratically elected officials representing this community are represented on the DOB. Independent technical expert through Dave Lockbaum, who is unpaid, purely independent, nuclear engineer, very well regarded in virtually all circles dealing with nuclear energy issues, as well as an environmental representative. The chat feature I've talked about before. I've even mentioned on this presentation, is reserved for logistical problems, and that's to ensure that the members of the public participating virtually get the technical assistance they need. But we do have a live Q&A feature that can record questions, and we do record those and answer those questions. And I'll just close with an observation from a pretty prominent environmental activist who has attended many of these DOB meetings, who said that the DOB has actually restored her faith in democracy, and that was something that I was very happy to hear. So we're never going to please 100% of the people, and there are varied viewpoints here that we're trying to balance. And we will continue to evolve and continue to listen to the public. I'll take the next couple as well. The next question from Courtney Williams regarding Dave Lockbaum's presentation on dry casks. Dave has regularly answered any questions that the DOB has given him. And his role is to provide the DOB with impartial information, analysis, and insights into the technical aspects of nuclear. If there are questions that we have on dry casks, Dave won't be shy, won't be biased. He will give us his view. On the dry casks, I will tell you that recently there was an Inspector General report on NRC inspection activities in the Southeast region. We've been reviewing that. Dave has reviewed that. And we will have, in the near future, a number of questions for the NRC as to how that IG investigation may impact inspection activities at Indian Point. Next question is, will there be a discussion of hardened on-site storage? We have had a number of discussions about on-site, hardened on-site storage. There have been a number of discussions on that front. Richard Webster, another of our DOB members, I think is attending virtually tonight, has posed a number of questions regarding that. We've had a robust discussion. I'm sure there will be additional discussions. There are a number of questions that were fielded by Holtec and by Dave and others on that topic that are available in our Q&A on our website. Okay, Tony, back to you.
Do we have Susanna on the line for a follow-up question? Go ahead, Ms. Glidden.
Yes, thank you. Susanna Glidden here. Well, it's good that you finally got to monitoring the air near the schools, but you go to many lengths to manufacture your self-promoting propaganda that try to deny you created an unlevel playing field with a one-sided presentation by industry and oversight agencies, rather than honoring the public's major demands of having a community representative on the board and inviting independent experts on health, safety, and emergency preparedness to present DOB. Now, what we millions of New Yorkers want at Indian Point.
Ms. Glidden, do you have a follow-up question?
Yes, here it is.
Thank you.
What we want at Indian Point is for Governor Hochul to immediately sign the Save the Hudson bill. And we want established up to a 2-year moratorium for independent testing of the wastewater and the river's ecosystem, a study on how to safely store the wastewater on site, and declaring Indian Point a federal Superfund site with health protective cleanup standards. That is what I asked if the DOB will establish.
Thank you.
I can take that, and John or the AG's office can chime in. But I will just start by acknowledging the statements, so thank you, Susanna. There are many points of view in this community, and we've discussed before at previous meetings the representation on the DOB. We believe that through the democratically elected individuals who sit on the DOB, that they represent all points of view in their communities, and they do it well. They respond to the community interests, and that feeds into the DOB process. As to whether the DOB would declare IP a Superfund site or have influence over whether or not the governor signs the bill, that's beyond the DOB. We're here to be the forum for information exchange. I can assure you that the transcript and the meetings are certainly something that the governor's office is aware of. They're fully engaged on these issues. I think they're doing their due diligence, but at this point, along with the hundreds of other bills that passed last month through the legislature, they're still doing their due diligence on that legislation. But John or AG's office, you want to add to anything?
Yes, I would just add for perspective from the follow-up question that the state of New York, its executive agencies, its Attorney General's office, where I worked for many years, has been at the forefront of advocating on behalf of New York State residents. I can personally tell you, Ms. Glidden, that for 10 years, I, and my colleagues at this table worked tirelessly on the Indian Point license renewal. So you're entitled to say that we are, engaged in propaganda or we are one-sided. From where I sit and from the experience that I have lived personally, I have to share my view that I disagree and reject your characterization that the DOB is engaged in propaganda and is one-sided. We are out there, state agencies representing the public interest and the interest of New Yorkers, and we do it fairly, objectively, every day. And just from a fairness doctrine perspective, we are fair and balanced, but we are also objective and informed, and we will continue to do so. Thank you.
We object.
Thank you.
We don't agree with you, Mr. Zachos, at all.
Okay. The next topic.
Tony, before you move on, I believe that Courtney Williams has joined via Zoom, so if she has a follow-up question, you can give her an opportunity. And before you do move on, it's part of my introduction, I should have made crystal clear that this is a public forum. It's not a meeting per se of the Decommissioning Oversight Board, but our Decommissioning Oversight Board, most of them are in attendance, either in person or virtually. including Assemblymember Levenberg, Catherine Borgia, Deputy Supervisor, Senator Harcum, Village Mayor Bill Smith, and others via Zoom. So I wanted to make sure I introduced the DOB members who are here and listening. Thank you.
Ms. Williams, did you have a follow-up question?
Yes, so my follow-up then would be, will the DOB be asking Dave to do a presentation on Holtec's dry casks and hardened on-site storage, and a presentation on who makes the call and what advocacy the state is doing to make sure that the way that the fuel is stored at Indian Point is as safe as possible versus what makes Holtec the most money by buying their own casks.
I'm hearing that as a request that we do ask Dave to make a presentation at a future DOB meeting, and we can take that under advisement and discuss with Dave that possibility. I think it's very possible.
And can we get a presentation on, what advocacy the state is doing to ensure the best possible method of storage? And I know that we've gotten report backs from the work you all are doing advocating with the NRC for different things. So, how can we advocate that the NRC put requirements in place so that companies, decommissioning companies like Holtec, can't just use their own materials to make themselves, pay themselves from the trust fund, and instead are using the best possible products on the market that ensure public safety and environmental safety?
Thanks, Courtney. I think I alluded earlier to one thing the state is looking into further, which is a recent IG report on NRC inspection activities pertaining to dry casks, and so we will have some follow-up at our next meeting in September to discuss that further. I think should Dave prepare some presentations on dry cask storage and hardened on-site storage, that there would be opportunity for further DOB discussions at that point. I'd also consider a future meeting inviting the NRC to discuss their oversight as well, and they're here, so I turn to them to see if you want to add anything to the question.
Sure. Can you hear me, Courtney?
You get closer to the mic.
Can you hear me?
Yes, I can. I was remuted.
Yeah.
Okay. My name is Paul Crone. I'm a director at the NRC. The folks in my division have oversight of dry cask inspection. So I just want to give you some high-level perspectives. In order for Holtec or any other licensee to use a cask, they have to use an NRC-approved design. So what does that mean? It means we spent a great amount of engineering analysis looking at these casks to make sure they're robust, they're put together properly. We inspect the supply chain for the components that go into them. And somebody like Holtec can only use a licensed cask. So that, what we call safety evaluation review, is available publicly, right? So you can see the detailed level of analysis we do. It includes all sorts of different external scenarios, severe weather events, and it describes numerous things. So we can present more detail on that later, but that is all publicly available. And we'll be answering some questions on dry casks later.
Good. Thank you.
Thank you. The next topic is workforce, and the questioner is Elizabeth Castaldo. The question is, are there any available job retraining programs for former employees at Indian Point to retrain them on working with solar or wind energy equipment?
Hi, Rachel Adler, New York State Department of Labor. Yes, the New York State Department of Labor, in partnership with NYSERDA and other agencies, is launching the Office of Just Energy Transition, known as OJET. This office will connect workers with opportunities of quality jobs, upskilling, and training with focus on servicing those who are traditionally unrepresented, especially within disadvantaged communities. The office is in the process of being set up and engaging various stakeholders that include labor, businesses, other agencies, SUNYs, community colleges, BOCES, and vocational training schools. Beginning next year in 2024, it is anticipated this office will oversee a fund of up to $25 million of annual for workforce training and retraining programs to prepare workers for employment in the renewable fields. NYSERDA has also dedicated more than $170 million in funding to support clean energy workforce and development trainings. Additionally, there are websites that are part of the written response that will show everything that's involved within those training programs. But I don't really want to read out the website URLs because they don't have short, like, backsplashes. The DOL also offers several training funds, including the Apprenticeship Expansion Grant for programs outside of building and construction trades. That process just closed on June 30th, but we are expected to launch the new round for 2024. And we also have additional funding funding and training opportunities. Local workforce boards, which operate primarily on federal funds, are generally able to provide training assistance on individuals in the communities they serve through individual training accounts. And SUNYs and community colleges have degree programs available, but they also work within the communities they are in to create micro-credential programs in various fields. Additionally, I just want to mention our rapid response team that works with Holtec and any of the individuals that may be getting laid off, works with them on a month-to-month basis. We send out any of our virtual career fairs, and New York State DOL is hosting a career fair for employees that are being laid off at Holtec August 16th from 1 p.m. to 4 p.m.
Thank you. And do we have Ms. Castaldo on the line or in the room? No?
Ms. Castaldo, if you joined by phone, please dial *9 to raise your hand.
Okay, we'll move on to the next topic. The joint proposal. The questioner here is Warren Smith, and the questions are, is the joint proposal predicated on the post-shutdown decommissioning activities report, or the PSDAR, and decommissioning cost estimate, the DCE, that was submitted by Holtec in 2019? Did all signatories have access to the PSDAR and the DCE prior to signing the joint proposal on April 14, 2021? And who signed the document, and what terms did the signatories agree to?
Good evening. If I may, my name is Ryan Tay. Warren Smith was unable to attend. He is addressing a personal family matter. He's authorized me to speak on his behalf. I do have text from him. If you want proof of that.
It's okay, sir. You can come up to the mic and we'll answer the questions that Mr. Smith posed, and if you have a follow-up on his behalf, you can pose the follow-up.
Yeah, he did. He texted me some questions that he wanted.
That's fine. So we can take the joint proposal questions that I believe our friends at the AG's office, who are key signatories, are going to take these.
Yeah, hi. Good evening, everybody. My name is Josh Talents at the AG's office. I'd be happy to answer these. So the first question is the joint proposal predicated on the documents mentioned, the PSDAR and the DCE. The answer is yes. The second question, did all the signatories have access to those documents? Again, absolutely, the answer is yes. So these are publicly available documents. Holtec filed them in the context of the NRC license transfer proceedings and also in the PSL Public Service Law Section 70 license transfer proceedings, so parallel proceedings and before the Public Service Commission in New York. I think everyone who participated in the negotiations and who signed those agreements ultimately was very familiar with them. So who are the signatories? They're listed on the front page of the joint proposal, which, by the way, is on the Decommissioning Oversight Board's website. Entergy, Holtec, Department of Public Service, Office of the Attorney General, DEC, NYSERDA, Homeland Security Department in New York, public entities, or the local public entities, the county, the town, the village, the school district, the Public Utility Law Project, and then also Riverkeeper, of course. So those are the entities that agreed to be bound by the terms of the joint proposal. So the third question, then, what are the terms? I think from a kind of a 30,000-foot perspective, the kind of two major areas the JP addresses are, one, financial assurance, which is to say, making sure that Holtec has adequate financial resources to complete this project. There's a number of ways the JP does that, including by establishing minimum balances in the decommissioning trust funds, by requiring additional financial assurance for site restoration, and then, importantly, by requiring that Holtec return reimbursements for its spent fuel management expenditures to the trust, which is unprecedented. There's no similar requirements and regulations, and it's not happening anywhere else. It's only happening here. And the second major area I think you could describe as transparency. And so that I mean making sure that the state regulators have visibility into what's happening on the sites above and beyond what we would otherwise be able to glean from Holtec's annual filings to the NRC. The joint proposal also incorporates a DEC order on consent, I'm sure many of you know, which will ensure that the site is restored ultimately to, or in accordance with state standards. And it addresses a number of other issues, including, Tom mentioned, pipeline safety, emergency preparedness, and the schedule for moving fuel assemblies out of the pools and into dry storage, which I understand will be complete by the end of the year. So, yeah, that's it.
Okay, he did have some follow-up questions. I just want to first, for myself.
Sir, could you just restate your name?
My name is Ryan Mulcahy, 9 Pond Road, Crampon, New York.
Thank you very much.
So I just want to say thank you to all of you for being here today, giving your time answering these questions. Again, I do see some members of the board, Senator Harcum, thank you. One question that he did actually want answered was from Mrs. Berniak. Would you be willing to answer that first question, what exactly was contained in the joint proposal? He was asking specifically that you answer that. I don't know, ma'am, I just have it in the text. He wanted you to answer that question.
I did talk to him a couple of meetings ago, so, okay. I think Josh covered a lot of the provisions that are in the joint proposal, which our office led the negotiations on. And as Josh mentioned, the big concern was that Holtec would prudently use decommissioning trust fund to and we wanted to make sure that the funds were expended in a way that was balanced over time as they completed aspects of the decommissioning. And the big issue is, of course, getting the spent fuel out of the pools and into on-site hardened storage. That's key. That takes the last big risk off the plate. So, and that, as Josh mentioned, that's going to be done by the end of the year. So there are financial provisions in there. There are financial guarantees and financial assurances that relate to the DEC cleanup agreement that DEC has with Holtec that will require cleanup of the site once decommissioning is complete to a standard below the 25 millirem standard that the NRC requires to the state standard of 10 millirem. So that is a provision that is also in that we negotiated in the joint proposal that ended up as a Public Service Commission order that is enforceable by the Public Service Commission at the state.
If I might just add a little bit of context, because some members of the public may not be fully aware of these legal terms about a joint proposal and what is governing here. So just to take one step back, before Entergy could sell Indian Point, this is a private entity that owned the site, that had the NRC license to operate as an operating nuclear power plant. If they didn't sell it, they would continue owning the plant into decommissioning, and they'd be responsible for decommissioning under NRC rules. So if they continued to own it, they could have continued owning it without it operating as a nuclear power plant. They would have had to transition to a decommissioning stage. And Entergy articulated that its plan on decommissioning, if they continued to own it, would be to decommission under NRC rules using a pathway that is approved by the NRC to take 60 years for the decommissioning and cleanup of the site. And they argued that, in their view, they were a company that runs power plants, not a decommissioning business, and that they did not believe the trust fund balance that existed was sufficient for them to complete the work immediately. So under NRC rules, you can keep the trust fund aside, it can accrue interest, the value of the trust fund grows, then down the line, they can start decommissioning. That's allowed under NRC rules. State would have no opportunity or role in accelerating that. The business proposition that Holtec and Entergy presented in their filing requesting NRC approval and requesting State of New York approval was essentially they take ownership of the plant, they take ownership of the trust fund, they take the liability associated with the cleanup, and they argued, we'll do it faster. Decommissioning is something Holtec was designing, creating a company to do. They would bring in the experts that knew how to do decommissioning. They believed the trust fund balance that existed at the time of sale was sufficient for them to commence decommissioning more immediately than Entergy. So that was their argument for why the NRC and the State of New York should approve the sale. NRC approved the sale before the state. Under the State Public Service Commission proceeding that reviews those sales under state law, parties can intervene and review the case, submit testimony, and make an argument for whether or not they approve, they support or oppose the sale. Most of the public comments and party testimony came in expressing serious concerns about the sale to Holtec, and many of those concerns were about the financial assurance and those kinds of things. So when those parties then entered negotiations that the AG's office led with the DPS, that was to address the party concerns. And so NRC approved it, no conditions. I don't believe there were any conditions. But Public Service Commission approved it with a number of conditions that were represented in the joint proposal, which they just described, all of those public interest conditions. So I just wanted to give more context for kind of why we were even in a place of having those discussions and negotiations around what conditions could be imposed. The conditions were meant to address the party testimony that was submitted in opposition or expressing concerns to the sale to Holtec.
Okay. You did have a follow-up question?
Actually, I'd just like to is John Sipos over here. I'd just like to underscore something else that my colleague Lisa Burianic mentioned. One aspect of the joint proposal and the Public Service Commission order was the agreement and approval for there to be a prompt withdrawal of radioactive spent fuel from the 2 remaining spent fuel pools and transferring that to dry cask storage. The existing pools were densely packed as a result of various policy decisions made on the federal level. That is a reduction of risk to the host community, the withdrawal and the removal of spent nuclear fuel from the spent fuel pools and transferring it into dry cask storage is the last large-scale remaining list to the community. And that is important, and that is something that the state, the Department of Public Service, the Attorney General's office, and the other state agencies, and Riverkeeper, and the Public Utility Law Project all agreed to was the movement of that fuel to dry cask. That is reducing risk to this community. Thank you.
So he, like I said, he did have a follow-up. What effect does Pete Harlem and Dana Lavenberg's bill have on the agreement if Governor Hochul signs the bill into law? Would that law then negate the joint proposal? That's his question.
Yeah, thanks. I can take that. So I think Tom did a great job of explaining how the joint proposal came to be, so I won't reiterate it, but I think it's important to maybe highlight in response to that question that the joint proposal was proposed to the Public Service Commission and approved by the commission, and so that the terms of that agreement are both binding on the signatories to it, the parties that signed it, Riverkeeper and the state, and et cetera, Holtec Energy. But the terms are also now enforceable by the Public Service Commission under that order. So all the obligations in that agreement are continuing obligations.
But if she signs the bill, I guess what I'm asking is then, does that negate everything if she does in fact sign the bill?
Yeah, I understand. I think the answer is that that order it's out there in the world, and it imposes obligations on everyone who's a party to it, and those obligations will continue regardless.
Okay, well, if the joint proposal is broken, could Holtec legally just stop the project indefinitely? If the project is put on hold for 12, 25 years, as been proposed by politicians, what is the cost to the Village of Buchanan and the town of Cortland in lost opportunities for revenue from taxes? That was his last question.
So I'm going to jump in and take that. I think, have to excuse the lawyer's response here. I think there are almost innumerable assumptions built into that question, and there is a lot of speculation built in there.
Okay.
I think...
Not my question, just...
I'm not commenting on it one way or the other. I think there are a number of assumptions built in there, and it would not be appropriate today to delve into essentially a legal discussion on that.
Yeah. And if I may ask the administrative law judge, try to limit the questioners to one follow-up, only so that we can get to all of the questioners.
Sure.
Thank you.
Before we'll do that,
Thank you.
His last follow-up question was actually another question we have on the next slide, so we are moving forward. Next slide. The topic is legislation related to water discharge. There are two questions. One of them was asked, so we won't have any follow-ups with that second one. But Courtney Williams and Warren Smith are the questioners. And what is the status of the bill to ban dumping? Why has Governor Hochul not taken a public stance on dumping the water? And the second question was already answered. What effect does the legislation sponsored by Senator Harkman and Assemblywoman Levenberg have on the joint proposal?
Yep.
Okay, thanks.
Oh, I thought they were already answered. We could probably just move on. But did you have anything to add, Josh? I'm sorry.
No, I don't think so. I mean, I think on what the governor is planning to do, I mean, that's up to the governor. I can't comment on that. And then I think we've already talked about the status of the legislation, right? Yeah, so, okay.
Yeah. The answer, and I discussed this earlier, is that there were hundreds of bills passed last month. All of them are being reviewed by the governor's office. So the legislation that's pending is still under review.
It's her answer, that's not her answer.
I'm the DOB, and respect.
There's no representative from the governor's office.
Respectfully, sir, we're trying to have an information exchange. That's the answer that we're providing. And if you could please move to the speakers that pose the questions, and we'll answer them. These are the factual information that we have, okay? Thank you.
The next topic is economic impacts related to water discharge. The questioner is Ellen Weininger. What New York State agencies have been consulted to evaluate the potential economic impacts of radioactive discharges to the Hudson River on recreation, tourism, property values, as well as employment and tax revenues from these multi-billion-dollar industries? Please describe findings. Please describe any and all independent expert economic assessments that have been conducted. If not, why not? Please explain.
I'm sorry. Excuse me. I'm being texted that we have an individual from EPA virtually who is going to need to sign off at 7. And I believe Ellen, hi Ellen, has another question that was related to the Pilgrim site. So if we want that question answered, we should probably move to that one. And since Ellen is already at the mic, proceed to that one. And that way we can then turn back to the previous. Is that okay?
Yes, that was the water discharge?
Yes.
Related to Massachusetts? Okay. The water discharge testing and protocols. Question is, the Massachusetts Department of Public Health released several reports on May 19th, 2023 regarding independent testing of split samples from the Pillar Nuclear Facility that has been undergoing decommissioning by Holtec. Among the 239 non-radiological pollutants that were tested for, 22 were present at concentrations above the detection limit. They include 9 PFAS compounds, 1 semi-volatile organic, and 2 volatile organic compounds, 8 metals, boron, cobalt, copper, iron, nickel, potassium, zinc, and cyanide, and 5 general chemistry measures: nitrogen nitrate, oil and grease, pH, total dissolved solids, and chlorine. The Massachusetts Department of Public Health report also revealed 5 radioactive isotopes above the detection limit: manganese 54, cobalt 60, zinc 65, cesium-137, and tritium. According to Ken Buseler, a marine radiochemist at the Woods Hole Oceanographic Institute, who reviewed the results, samples of tritium, a radioisotope that cannot be treated, averaged about 100,000 becquerels per liter, about 1 million times higher than the average background level in the ocean. The numbers for cesium-137 in the untreated water are 200 million times higher than what's in the ocean right now. Further tests will be needed to determine levels of other radioisotopes such as carbon-14, strontium-90, plutonium, and uranium, which require more advanced testing. Once you see these other isotopes at these levels, you know there's other forms of radioactivity than just 5 radionucleotides. Buseler says the best solution for the wastewater is stored on-site after it is treated. Describe the steps that the U.S. EPA Region 2, New York State Department of Health, and New York State Department of Environmental Conservation, and other state agencies are taking to ensure the implementation of comprehensive, transparent, independent, expert analysis of the wastewater proposed for discharge from Indian Point are conducted. What analyses have been conducted to date? What is the inventory of radionuclides from Indian Point fuel pools? What radionuclides will be tested? What non-radiological co-pollutants will be tested? What is the timeline for independent expert analysis? What protocols, specific testing equipment, and certified laboratories are involved in the process? What qualified independent experts are involved in the process?
So first, if we could turn to our friend from the EPA Region 1 office, who's on the line?
Yeah, can you hear me? This is Lynn Jennings, just...
Yes, we can hear you. Thank you.
Okay, sorry, my video won't turn on. I think you guys might be blocking that. That's fine. So yeah, there's a lot of questions in this particular slide. I think actually many of these are directed not to EPA Region 1 in Boston, but rather others in Region 2 in the state, et cetera, about the testing of water at this particular facility. So I just wanted to give a little bit of background about what's going on in Massachusetts with the Pilgrim facility. That's a facility located in Region 1, and is also going through decommissioning, also by Holtec. We have similar questions being raised. Probably the most pressing in our region is the discharge of spent fuel pool water as part of the decommissioning process. And we've got a lot of conversations with the public and with Holtec regarding this discharge. And the situation in Region 1 is slightly different. I wanted to just explain that. So first of all, earlier this year, Holtec submitted applications to both Massachusetts DEP and US EPA requesting that we modify Holtec's existing state and federal NIPDES permit for the former Pilgrim Nuclear Power Station in Plymouth, Mass. Holtec's state and federal permit that's currently in effect was actually issued jointly by Massachusetts DEP and EPA on January 30th, 2020. Holtec's recent application request requested that the agencies actually modify this permit, our respective permits, the state permit and the federal permit, to authorize Holtec the discharge of treated spent fuel pool water and other wastewater associated with decommissioning. So we have received this application, and EPA was independently or evaluating the application and evaluating whether or not we were going to modify the permit to allow the discharge of this water. Now, what's unique about Massachusetts is that the state of Massachusetts was never granted delegation authority to issue permits in Massachusetts. So EPA Region 1 issues all of these permits. What we had done for a period of time is issue them jointly with the state of Mass. So there was a joint signature on the permit itself. And this permit that Holtec was operating under was issued in 2020, and it was a joint permit. In 2021, actually, we changed our protocol. We no longer issue joint permits with joint signature. EPA will issue its permit individually, and the state of Mass will oftentimes issue their own, and they essentially adopt the EPA permit, and then they add some state-specific requirements that go above and beyond EPA's permit. So that is one unique aspect. I know folks have been asking what EPA Region 2 is doing. We do have a different relationship with the state of Massachusetts than EPA does here in Region 2 in New York State, where in this case, the state of New York is the permitting authority and permit decision maker. But a new development in Massachusetts that you may have heard, actually last week on Monday, the state of Massachusetts actually issued a tentative decision, a proposed decision, to deny Holtec's request to modify their existing permit, their state permit. And we haven't had a chance yet to fully evaluate what that denial means for our federal permit. And we actually have meetings scheduled with the state of Massachusetts toward the end of this month to walk through how that will affect and whether EPA can actually modify their permit. The state's decision is based on a state law called the Oceans Sanctuary Act, and it was put in place back in the early 70s to protect Cape Cod Bay, and it has boundaries in the area that has been identified as a sanctuary. And that act actually prohibits the discharge of municipal, industrial, commercial wastewater into that area, unless it meets certain exemptions. And this new discharge that Holtec is asking for modifications to their permit for is not one of the exemptions. So the state has issued their tentative decision. They are seeking comment on that. The comment period on the decision will run until, I think, the end of August 28th. So again, we are in the process, we haven't had a chance to fully evaluate the impact of the state's decision on EPA's federal permit. But I did want to, be here to answer any questions folks may have. Separate and apart, as you know, based on the slide, the state of Massachusetts did in fact go in and sample the wastewater that Holtec was proposing to discharge. Holtec knew they would need to submit to us an official application, which they have done. But because of public concern, the public requested split samples of this water. They didn't trust that Holtec would take samples appropriately in the right locations and all of that. So the state went in and took independent samples, and these are the results that are on this slide. So I'm going to pause there because I spoke for a few minutes and see if I think somebody else will have to answer to whether the state of New York will do something similar. But I can certainly answer anything related to what's going on in the Region 1 building site.
Thank you for that. Does NRC want to add anything to the split sampling that's been done?
Yeah, just a short comment, Tom. This is Paul Crone with the NRC. I compliment the questioner on the diligence of the question, very thorough, so I appreciate that. The numbers and the context of this question is for what we would say is untreated water. It hasn't been run through any cleanup systems to remove any products. What we would regulate from an NRC standpoint is what gets discharged to the environment. So the numbers here are before any filtering or remediation, if you will. And let me see if Bruce would like to add anything. It's an important distinction to make.
Yep, thank you.
I was just going to reiterate, this is Bruce Watson, what Paul just mentioned. The numbers in here are great. They're unfiltered, unprocessed. The utility, or in this case, the licensee, would be responsible for filtering, processing, and reducing these the contaminants, especially the radioactive ones that we regulate, to as low as reasonably achievable. And we would be monitoring and controlling regulating the actual radioactive discharges. And that is done in accordance with the part of the license. It's incorporated into the license, the off-site dose calculation manual, which NRC approves. It's a very lengthy document on the steps they would take to monitor, treat, monitor, and discharge the water and calculate the dose to it in advance of the actual discharge. So everything in the radioactive area is comprehensive. I've listened into the Pilgrim meetings. The Massachusetts Department of Public Health is doing independent or splitting samples with them to verify all the results that's been reported to them, and will continue to do so, as far as I know, into the future for the non-radioactive components. Thank you.
Thank you.
If I could add one more thing regarding that, and that's 100% accurate. When we issue a permit for the water, it is for the treated water, and we do have information from Holtec, as part of their application for discharge on what they expect to be in the treated water. And when we make our permit decisions, it is based on that data that we would establish limits, monitoring requirements, etc. And our permit, if you probably know this, our permit will be for the non-radioactive components.
Thank you. And to the questions pertaining to the state process for doing sampling, we've presented at previous DOB meetings the DOH plan for doing a sample analysis of the treated water prior to discharges occurring, should they go forward with that plan. So that hasn't been done yet, but they have a protocol established by the DOH and Holtec, which we've presented at previous meetings.
So may I follow up?
Sure.
Okay. First of all, I appreciate the responses from the various speakers. They didn't actually address the question that I posed in this particular question, which was very specific information about the testing. And while there was a presentation at the last DOB meeting, there were many questions that I'm raising here that were not specifically described. Very specific information about protocols, specific testing equipment, the certified laboratories, what qualified independent expert is involved in this process. Also, while we're bringing up that last meeting and that presentation, there was mention of or at least there was some indication of, the testing, and I noted in I believe it's a memo of understanding, some of the items, I don't have that here in front of me, that memo of understanding, but in terms of that agreed testing, it doesn't even mention PFAS chemicals, and the testing that was done by the Massachusetts Department of Public Health was done in the spring. Results came out in May, and there's no mention of testing for that. There are many other questions around that memo of understanding, but I specifically asked for those details at the bottom of the question. I decided to give the background of the Massachusetts Department of Public Health's findings specifically because it gives a framework and informs the process for New York State. They're a few steps ahead, and we should be able to learn from that and proceed from there. But it doesn't appear to be the case, and I still don't have answers to the questions that I asked, although I do appreciate everyone pitching in. And in terms of treatment, I did pose a question about the treatment systems and oversight around that. I'm not sure that it made it into your list of questions, but given the fact that someone did respond that this isn't treated, I would comment and ask the question. Again, according to Ken Buesler, who is a marine radiochemist at the Woods Hole Oceanographic Institution, who reviewed the Pilgrim analyses and the sophisticated cleaning system that he mentions would be required and probably would require more than one treatment. So he mentions even if treatment removed 99% of the cesium, the resulting wastewater would still have levels 2 million times higher than what's in the ocean. And so it would have to go through treatment again and again and again.
Ms. Weininger?
So here's my question,
Okay.
because it was referenced here. What kind of treatment system is Holtec planning to use, and who's evaluating that treatment system, who's verifying its effectiveness, what radionuclides will be treated, what independent experts are verifying and providing analyses over this treatment system, and here's the key. What are the results of those independent findings, and how many rounds of treatment are planned for each batch of wastewater, and who makes that determination? Holtec or some independent expert? How is that determination made? And what radionuclides remain untreated in addition to tritium? And what agencies and by what means will those radionuclides be tracked if discharges are permitted? And what agencies or who provides oversight of the treatment process? And describe the oversight of the treatment process. And what agencies provide oversight of the discharge process? Describe that discharge process. So you referenced it, I didn't, you didn't have it, I don't think it was in your list.
I'm going to
but
turn it over to the panel to see if they can answer.
You've got
Yeah.
lots of
Number of follow-ups.
lots of
Thank you.
issues here.
No, thank you for the follow-ups, and please stay at the mic because I think we'll turn back to the question
Okay.
that you came up to the mic
Thank
for. I'll start with NRC and then we can go to the DOH.
Okay, this is Bruce Watson again from the NRC. What nuclides will be tested? The radionuclides are outlined in the off-site dose calculation manual, which is publicly available on our website for the Indian Point site and all the nuclear power plants countrywide. Like I said, it's a very thick document, identifies all the radionuclides of concern that would be needed to be tested. Now, who's going to test those or analyze those samples? In the United States, there is a DOE laboratory intercomparison program, which the DOE runs at the Idaho National Lab, the Radiological Environmental Sciences Laboratory, which accredits all the laboratories in the country. And all laboratories, I'll say, not only say all, but most laboratories, at least the ones that we hope our licensees use, participate in those intercomparison studies to analyze radionuclides to ensure they're making accurate results, providing accurate results. If the NRC does samples, we send them directly to Russell in Idaho, which is the country's world-class laboratory for radiological measurements and for the analysis. So we will go to that independent laboratory for any of our results. So that's how the system works. Holtec will contract a company that is hopefully a accredited or certified laboratory that participates in the DOE laboratory intercomparison. You can look on in the DOE website and you can see how all the different companies line up in their performance of all the nuclides and analytics that they do are permitted or are certified to perform. So it's a very open system and it's a very analytical system that has lots of quality assurance requirements for the laboratory, and of course there are labs that we use should we want a sample analyzed. Thank you.
DOH, Alex Damiani?
Sure, my name's Alex Damiani. I'm with the State Department of Health.
So with respect to the radiological analysis that the state will do, and we've been working with DEC, who will cover the non-rad component, but the State Health Department's lab, Wadsworth Center for Lab and Research, will do the radiological analysis. Generally speaking, most of their protocols follow various EPA methodologies, and we listed these answers on a previous meeting where we spelled out they're the 900 series for the EPA rad testing. The proposal currently is to do joint sampling with Holtec prior to discharge of the wastewater. And the frequency, the exact analysis is spelled out, but for the most part, we'll do alpha, beta, gamma. We'll do a full spectrum of pretty much everything. The agreement required, I believe, a 12-day wait before Holtec would discharge any water based on typical return times for us to get assessments. And that covers most everything except strontium-90. That takes about 3 months to get accurate results for. So, trying to think, what other questions did you have? I forgot now.
Again.
In terms of just the rad
Yeah,
analysis that
yeah.
we'll be doing.
Again, my question is around qualified independent expert and
Okay, so,
independent analyses and independent verification around all of these questions that are posed that are still here.
Okay, so the State Health Laboratory is staffed by a half dozen PhD radiochemists who are also faculty at SUNY Albany in general. They are published independent experts in the field. Right? The laboratory is top-notch. It may not be the equivalent of the Idaho National Lab, but it's probably second only to a few of the national labs in their ability to detect low levels. And part of that is just a quirk of fate. They have a 42-story building over them, so that gives them incredible shielding, and they're able to detect very low levels that many other laboratories cannot. So with respect to their ability to detect, I think you're in very good hands with the State Wadsworth Laboratory doing those analyses. So.
And there is a one-page summary of the sampling protocols on the DOB website, if you haven't seen that already.
Yeah.
But if we could, in the interest of time, turn to your original question that you came up for?
Well,
Oh, I'm sorry, yeah?
that was, and then the other point that was made was, again, in the course of various speakers speaking about the discharges, and again, so I'll follow up with a question. We're not arguing that the NRC has jurisdiction over the concentration of tritiated water in the tanks and the fuel pools at Indian Point. I'm going to follow up on that point, is that NRC's legal jurisdiction ends at the moment that that water reaches the Hudson River. So my understanding here is that something on the order of 80,000 gallons of Hudson River water would have to be extracted quite frequently during the course of a day in order to dilute the radioactive material that is needed to discharge, and it will have to go through that circulating water system in order to achieve the dilution. So again, there's this back and forth about who's responsible, who has authority,
What is
and
the
so
question,
forth.
Ms. Weininger?
Well, I'm following up on someone's statement about NRC's authority here, and
Okay.
where,
You just
and
asked
there
the
was
question.
mention. Yeah, so
Please.
I'm saying that the state has authority here over these discharges because it's withdrawing so much water from the Hudson River in order to dilute it and then go through a circulation system
Okay, I'm
and
still
then
not hearing your
discharge.
question.
So I'm asking what is the state, how is the state asserting its authority here?
Okay.
Because we keep hearing, and I just heard it moments ago, that the NRC has
Okay, I
the
heard
authority
your
over
question. Let's
this.
see if we can get an answer.
Paul Crone, NRC. Hopefully this helps. You're right about this 80,000 gallon number, but let me try to give you some context to it. The licensee uses a process called batch discharges, so they do it in a batch. So Site VP for Holtec mentioned this last DOB meeting, about 1,800 gallons.
18,000
18,000?
gallons.
Okay, thank you
Yeah,
for
in a
that.
batch. Yeah.
When you take a couple hours to discharge that, you turn on a circulating water pump. It's a pump on the site when the plant used to be running, and that goes through the discharge canal, comes out of the river and goes right back into the river. It's just a recirc, in and out. And while that 80,000 gallons is flowing, you've got this other pump with the liquid effluent, potentially, if Holtec discharges, going into the river. So that's a dilution factor. That's included in the calcs that the licensee has to do that we come back and verify. So that's the process they use if batch discharges were to occur during the decommissioning process. Does that help?
Right. Well, it sounds to me like 80,000 gallons per minute of clean Hudson water, river water, would be extracted, and then it gets contaminated with the radioactive
Gets
water on
mixed,
site.
and it's
Yeah, it's
returned.
mixed.
It
That's
gets
right,
mixed and
it's
returned.
contaminated.
That's why it's called a dilution factor. Now, you have to understand that what we regulate, what we, the NRC, regulate is the amount of activity that goes to the environment, right? And all our regulations and the limits are built around those isotopes and that amount of activity. So whether it's 80,000 GPM and X curies, what we're trying to get to is curies, right? Concentration, flow, we care about content of curies going out. And Bruce, I don't know if you want to elaborate.
Yeah, this is all spelled out, as I mentioned, in the offsite dose calculation manual. The requirements for discharge, 18,000 gallons are typically discharged at about 2 gallons per minute, and it's mixed. The circulating water system, I think, is around 180,000 gallons per minute, so you're taking 2 gallons and diluting it with 180,000 gallons when it's discharged to the river, back into the river. And so there is a significant dilution factor. From that, we do calculate a dose at that point where the radioactive discharge is met, not where it's after it's really diluted in the river with all that
Right.
water. So,
But this is
thank-
not part of the safety issues preempted by the NRC. This is under New York State's authority. This has to do with releasing these effluents through the circulating system, extracting 80,000 gallons per minute from the Hudson. So,
Do any of the lawyers up here want to address the extraction of the water issue?
Hi, it's John Sipos. I'll provide a response, but I actually have some questions for NRC. For the release of radiological material to the Hudson River, what agency oversees and regulates that?
Radiological release is the NRC.
Thank you.
Non-radiological release is another agency, they can speak here in a moment. And that's authorized by an act of Congress, Atomic Energy Act. That
Thank you.
falls to us.
Thank you. So I think you've heard the answer from the federal regulator. I think we've had this discussion at previous DOB meetings, both in June and earlier. And that is the legal framework for what occurs at the operation, under the operating license, under the federal operating license for this facility.
all right. New York State is an agreement state, though. You acknowledge that.
Okay, I think we have to move on.
That is part of a question anyway, so I'll hold it until the question comes up later, hopefully.
Okay.
So we've read this question in already to the record, Tony. I don't think you need to repeat it. The request was, what has the state done with respect to evaluating the potential economic impacts associated with the potential discharge?
Yeah.
And the answer is the state executive agencies have not done such an analysis of that. The legislature may have, that supported their legislation that was based on that premise. The economic impacts that have been addressed by state work have go back to around 2017, when there was the original closure agreement. When we announced that publicly, we created the closure task force, and one of the very first issues some of the local electeds raised was what the economic impact of the closure would be on the communities, the loss of tax revenue, the potential impacts on property values, the potential future reuses of the site. And there was a request made at that time that we do a study, and I sort of contracted with an outside entity that examined the potential reuse opportunities post-decommissioning, and whether or not any part of the site that wasn't radiologically contaminated might be released prior to decommissioning being completed. So that work was done back in 2017-18, and that report is available online. We also had a number of presentations back at that time from real estate agents that had been concerned what closure might mean for the local economy. And after the closure agreement, and even maybe after the closure itself, we had real estate agents come and present whether there were any changes in the real estate market, and they reported none at that time.
Right.
But that wasn't pertaining to the water discharge, but that's the only economic analysis and work that I'm familiar with from the state DOB or task force.
Right, so there's been nothing, along the lines of the impacts, for example, of the radiological discharges, potential radiological, potential impacts to tourism, as an example. I mean, we know that it's a multi-billion-dollar industry in the Hudson River. There's plenty of reports out there. Tourism Economics shows in 2019, $4.5 billion in the Hudson River
Ms. Weidiger, did you
Valley.
have a
So
follow-up
again,
question?
that's the question, is that
Yeah,
the
the question
larger
is that-
picture
yeah.
has not been
There hasn't
addressed.
been. I would, I guess,
Is one planned?
right, we've not evaluated this, that study has not been done.
Is one planned?
Is one plant?
Are any independent expert economic assessments planned?
No, I think that was the premise behind the legislation, so I think that the legislature may have done some analysis of that, since that was the premise of the legislation, but I'm not aware of any analysis.
Okay. Thank you.
Thank you. The next topic.
Thank you very
is
much.
Testing and protocols. Please provide the chemical and radiological content of the prior to treatment and then treated effluent, including levels of PFAS, PFAOs, PCBs, boron, tritium, Crichton 85, Crichton 85M, cesium 137, strontium 90, and carbon 14. And the questioner is Susan Shapiro.
And Susan, keep in mind, you have a number of questions following, so in your follow-up, you can stick to this topic.
Okay, I will.
Department of Health want to begin on this one?
I just want to say it's Krypton, that's a typo, there's a P in there.
Yeah, I was going to say, that was my first thing. It's Krypton 85 and 85M.
Krypton 85M.
So I can, again, speak to the radiological components and what we will be testing and what we have, not specifically what is in the pool. That I wouldn't be able to tell you, but in terms of just what do we routinely assess for in our surveillance programs. So a general assessment will be a gross alpha, gross beta, so that'll look for any alpha emitter.
I'm having a hard time hearing.
I'm sorry. So our general first pass assessment will be a gross alpha, gross beta, looking for any alpha emitters, any beta emitters, and then a broad gamma isotopic analysis. We'll do very specific ones in the case of like Indian Point area. Tritium is a special one. We do that only in a few locations. We do one at the discharge canal. That is a sample we receive from Holtec, so we do a tritium assessment on that. Tritium assessment would generally also, or I'm sorry, water assessment would also be done by the water districts. If you want to see what your water district is testing, you have to go to the locality, the town, county, village, whatever your water district is, to find those testing results. So just very broadly, going back to the agreement that the DEC, DPS, DOH are working with Holtec for, we would do a very broad spectrum, gross alpha, gross beta, isotopic gamma, and I do not remember the specific. There's about a dozen, 8 or 10 different isotopes we'll be looking for under gamma spectroscopy. And I believe that document is posted on the
The one pager on your
the
sampling
one-pager that
protocols?
lists,
It
that
is.
does list the isotopes we'll be checking, and that is on the DOB website. That's on the non-rad side, or I'm sorry, on the rad side. I can't speak to the non-rad side specifically, what will be on there. I believe they were going for the 200 and some EPA listed chemicals, but I don't want to speak for the DEC, and they're not
That's what
present
Kelly
today. Yeah, we'll let
Turturro
Kelly
raised at the last
raise it.
meeting.
Yeah.
That's correct.
Will they be testing for the PSOAs and
So that was-
PCBs?
To the extent PFAS is not included in the 241, there was a discussion in the 241 chemicals listed in the EPA, right? And I don't know if DEC is on virtually and want to address that, but Kelly Turturro was evaluating how they would do PFAS in addition to the 241 chemicals on the EPA list.
Okay.
That was in following up on the question from the previous meeting.
Okay.
I don't know if DEC wants to add to that answer at all. Hearing none.
Okay.
That's the DEC's plan, as I understand it.
Okay, so my follow-up question is, they're planning to dump, they're saying September 15th. You're saying it's going to take 3 months for that, to get results on strontium, 85, 90?
90,
And so, what?
strontium 90.
90, I'm sorry. When is this testing going to be made available to the public? When are the results going to be made available? It seems illogical and sort of abhorrent that right now their testing hasn't already taken place. If in fact they're planning to dump on September 15th, testing should have happened months ago. So what is the status of the testing? Where are we?
The
Apparently it
testing-
hasn't happened yet, right?
The testing is going to be done after the treatment, and the treatment hasn't been done until, when the treatment is done and they're preparing for the discharge, is when we would grab the sample out of the treated
But you're planning
one.
to dump before the strontium results come in. Strontium causes bone cancer in children. It causes leukemia. It goes into the bones of children.
Your
This is,
question was whether they're planning to dump it before the results of the strontium are in?
yes.
That is correct. The
That's
results
insane.
will cover everything else, the gross alpha, gross beta, and other isotopes will be tested. And those are the ones that are more typical of what you would see in the expected discharges.
We know that there's strontium-90 in the water because at the desal plant in Haverstraw, in the pilot plant, they found strontium-90. So we know it's already in the effluent that's released, has been released historically, or accidents at Indian Point. So it will be probably in there. So we want to know for sure it's not going to be released. You should be, the DOB should be saying, this dumping cannot occur at all until the test results are in. That's simple logic. I mean, I don't think I'm asking for a lot.
The NRC may also want to weigh in on this matter. Go ahead.
Strontium in particular, other isotopes. And first, it's good to have a chance to talk to you again. I know we've had a chance to talk before. Let's talk about past experience and what you can look at as a member of the public. Every year, the licensee, in this case Holtec, has to submit a report to the NRC, and I have a copy, I think, in my briefcase I could share with you after, and it's for 2022. It says, I made so many discharges, and it breaks down all the isotopes, including the ones you're talking about. And it says, here's the quantity, and then you can compare that to our limits for that isotope, and you can see that it was either within the limit or not.
That is irrelevant. Historic data on that is
No,
irrelevant. We're talking about what they're
yes,
planning to
you're
dump
not
from the
following
spent
me, Susan.
fuels.
Could you let him finish?
Okay.
If, and what you're saying is a hypothetical scenario, Holtec made this discharge, we would know the quantity, and you'd be able to find the result. And if enforcement action was necessary, you better believe we'd make it, but that's a hypothetical.
It's after the fact. It's after they dump.
No.
It's after they dump. You're saying, let the results be found from the independent testing as well as from the NRC's testing before any dumping occurs. It's just simple protocol that you should have the results before you do the dumping. We have a history here, we have a history in the Hudson River of PCBs being dumped in the Hudson River, and everyone said, no problem, no health impacts. And we spent billions of dollars cleaning the Hudson. We're still cleaning the Hudson of PCBs. So we have a history here that we don't want dumping to occur until test results are in. It's not a big ask.
Okay?
Wait, I have
Let's take
a
the-
question.
let's take the
May I
higher
ask a
level
question?
here. Let's take the higher level here, Susan. We, the NRC, are a strong and independent regulator. If Holtec makes a mistake, we will call it on them, and you'll see it in
And
enforcement.
how are you going to clean it up once it's in the river? Are you joking? I'm asking you a serious question. You're joking, right? You must be.
If they discharge within our limits, carries protection for the public.
How do you know until the test results are in? You don't know ahead of time unless you are, a seer and can look into the future. I don't know how you know until the results are in.
You're asking me to speak for Holtec's actions. I will not do that.
So then tell them they can't dump until the results are in.
Sir.
So I am asking,
We can't be, excuse me, I'll let you finish. We can't have outbursts either while people are asking questions or people are answering them. If you have another question related to this, I appreciate the fact that you didn't like the answer you got, but if you have another question, you can ask
Yes,
it.
I do.
You also have a number of other
I do.
questions coming up.
So I will save my other
After one
questions.
more question, we're going to move on to the
Okay.
next topic.
Okay, I first want to say, I'm asking very simply that the NRC, the EPA, the DEC, the AG's office say there can be no dumping until all test results are in. It's not a big ask, period. That's what I'm asking.
Okay?
And, okay, and that should have been in the agreement. It doesn't make any sense
Okay, we're
at
going to
all.
move on to the next question.
Okay.
Related to water discharge and tritium. And again, Susan Shapiro, what is the total amount of tritium is projected to currently exist at Indian Point that needs to be either be disposed of or stored? And what is the total amount of tritium that has already been released during operations at Indian Point?
Paul Crone, NRC. I'll let, after I make some initial statements here, Tony Dimitriadis, add anything if you'd like. Total amount of tritium in the spent fuel pools currently is approximately 40 curies, give or take. That's a number. That represents activity. What's the total amount of tritium that has already been released? In a previous DO meeting, we had a very good summary bar graph. It has year on the horizontal axis, on the vertical it has a volume discharged and the number of batches. Bottom line is, when you look at that and the amounts that potentially could be discharged here, it's a small fraction of what was discharged during operation. Okay?
How much, I'm asking the question, how much was already
I
discharged?
would have to go back and sum them up. I don't have that answer off the top of my head.
Could you please provide that? It would be helpful.
Let me turn it over to Tony, see if he wants to add anything.
Sure.
So the amount of tritium was answered?
State your name, please.
I'm sorry, Anthony Dimitriadis, I'm the branch chief responsible for decommissioning of Indian Point, Pilgrim, Oyster Creek. I apologize for my voice, I have a little cold, almost over.
But he's not contagious.
The amount of tritium was already answered. The total amount of tritium, we can get that information. Indian Point has been releasing, discharging, not dumping, discharging after analysis for 60 years. The amount of radioactivity in relation to cancer risks is measured in millirem. I know that's a fuzzy term, and I appreciate the frustration. So our regulations outlined in 20.1301 talk about 100 millirem. The EPA regulation is 25 millirem. The ODCM, I believe, is like 3 to 9 millirem. And Indian Point has been releasing for 60 years and is proposing to releasing less than 1 millirem, actually 1/10 or 1/100th of a millirem for years. This relates to the other question that you had about what confidence do we have about strontium-90, various other things. They've never come close to our limit, and so this is the level of confidence that we have about that, and we inspect that annually. Thank you.
I want to ask a question about how this would be, apparently you're releasing, it has been being released. How is this being monitored? Historically, there seems to be a very large contradiction. I'd like an answer to this. Historically, the monitoring at Indian Point was perimeter monitoring, because we were repeatedly told at every NRC hearing that the NRC only monitors the perimeter because they're not responsible for any radionuclides that leave the site. Their jurisdiction ends at the perimeter. So now we're hearing a contradiction. It's a total flip. And the laws haven't changed. Something else has changed. So I'd like to get clarity. The NRC has only ever monitored at the perimeter. The DOH has only gotten data from the NRC's monitoring from the perimeter and never released off-site. So now we're being told, no, the NRC can release anywhere in New York State, on any of New York State's waterways, because they can release radionuclides wherever the hell they want.
Can someone
That's
on the
not true.
panel respond to the?
Yeah, I'd like to respond to that.
Yeah, go
This
ahead,
is Bruce Watson. The actual release of this material is done in accordance with the safety analysis report for the site, along with the, like I said before, the off-site dose calculation manual. So there are requirements to where that water or release can be done. If you want to consider it, the discharge conduit, which the water is released through, is part of the site, and the dose is calculated at the point of discharge. And so that's where we do things. You can disagree with me, but it's maybe part of the decommissioning plan if they pull the discharge conduit out. But it is part of the site, and it's in the description of the safety analysis report. Now, so we monitor, the off-site dose calculation monitor requires that the water be released in batches. It is pre-treated, it is sampled before it is released. It goes through an online monitor along with a pump which is calibrated, and the detector is calibrated to make sure that it's set, the water as it's being discharged, I think it's only a couple of gallons per minute, is monitored by this radiation detector, and if it goes above any preset limits, normally administrative levels, before they wanted to stop the discharge before it goes over any NRC requirements. So the water is monitored as it's being released, along with it having been sampled before. And then also on that, most sites have a composite sampler, which basically takes a few drips off of each the 2 gallon per minute pump. So that is then collected, and then again, it's analyzed for what was the final product that was discharged from that tank. And so that's another quality check that's done on the discharge to make sure it's meeting requirements in their off-site dose calculation manual. So, Tony, did you want to add something?
Can I just follow up a little bit?
Yes, sir.
May I answer your question, Susan? Anthony Dimitriadis, NRC. The reason the NRC requires the licensees to monitor at the boundary is because that's the highest concentration it would otherwise be. And therefore, if it meets the NRC limits at the boundary, at the highest point there, then if it goes off-site, it would actually be much lower. That's why we do that at the boundary. Does that answer your question?
We're going to move on to the related topic, water discharge, water storage tanks. Again, the questioner is Ms. Shapiro. Has Holtec submitted an application to the NRC for any storage tanks at Indian Point? If so, when? And please provide the application. Has Holtec submitted any applications to the NRC for storage tanks at any other facility? If so, when? And please provide the applications and decisions. Approximately, how long would it take for the NRC to grant approval of storage tanks once applied for? Please explain the application approval process. And what is the difference between approval of radioactive effluent storage tanks and spent fuel casks?
Yeah, this is Bruce Watson from the NRC. To the best of our knowledge, Holtec has not submitted any applications to the NRC for the construction of any storage tanks to store liquid effluent water that could be discharged. In accordance with their Part 50 license, they would not have to submit an application. However, they would do what's called a 50-59 safety screening, in which they would compare that activity with the requirements in the license. If they were compliant with the license, then they would be able to construct the tanks. However, we would inspect those tanks during the construction. We would also verify that they met certain standards for the construction of the facilities. To the best of our knowledge, we do not have any applications for any other sites for storage of water. The actual sites came with a number of tanks, which are generally reused. There's a condensate storage tanks, there's refueling water tanks that all meet all the codes for storage of water that plants generally reuse. Right now, I think Indian Point is using the fuel pools and also can use some of the other storage tanks on site for storing radioactive water, including the refueling water tank. How long would it us to grant approval? Well, we don't grant approval unless it's outside the license, then they would have to come to us for with that approval. However, I would believe that they could build these tanks without our permission. However, there may be other requirements for construction and demolition on the site, either by the state or the local authorities for construction of materials or changes at the site. So we would not take that. If there was a requirement for us to approve something, it would probably generally take about a year. Most of the license amendments and exemptions take about a year. This question about the approval, distance between the approval of radioactive effluent storage tanks and spent fuel casks, basically it's two different regulatory requirements. Spent fuel casks are licensed under Part 72, and they have their own requirements. And so they are on a separate license. In order to use those casks, the licensee has to apply to say that they're going to use those casks and provide us with the evidence that they know how to do the spent fuel loading and storage and design a facility that will safely and securely manage those facilities out into the future. So there's a distinct difference. Now, I just want to be clear on one thing, that the license for the Part 50 license, at the end of this, at the end of the decommissioning, we will actually call it a termination of the operating site, but it's really a partial site release, so the license will be shrunk down to just a dry fuel storage facility. In this case, we will be issuing what's called a Part 50 general license, which is basically the same thing as a Part 72 license for the dry fuel storage facility, just has a different name. For whatever reason, those regulations were written in parallel and allows the licensees to do that. So I just want to be clear, there is a difference between a Part 50 license for decommissioning and operating the plant and a 50 general license, which means that they're allowed to possess the spent nuclear fuel.
Anything else from the panel on the storage tanks? Do you have a follow-up question related to storage tanks?
Yes, I do. Has there ever been an environmental review on any level by any agency about storing the spent fuel tanks at Indian Point indefinitely as a temporary or a permanent waste storage site? Has that ever occurred? Or is the NRC just approving it on their own, allowing the Indian Point to be turned into a waste storage site?
Well, this is Bruce Watson again. I'll just briefly mention that for the site, there was an environmental impact statement that covered most of the things we've talked about here tonight.
It didn't cover the spent fuel
I
storage?
know, I'm getting to that, please. Okay? And there's also a current environmental assessment which talks about all the various changes that have happened since the environmental assessment impact statement was done, which there are changes in the environment, endangered species changed during that, so that looks at those types of effects. The ISSC environmental assessment is done in conjunction with the existing environmental assessment for the site, and it's licensed under that similar document, same document, I'm sorry, for the use at the site. The site has already had an environmental assessment done.
Not for spent fuel storage.
Excuse me, Susan, we have
Okay,
other
let's go
topics
ahead.
later, and you will be called back
Okay.
up to the mic on some of these issues, so I
Can I
want to
just
stay
ask-
on topic of these questions for
I
follow-up.
understand. It goes to these questions, the spent fuel storage. Just a quick question that I didn't get to ask, just quickly about the tritium, has there been an evaluation of the bioaccumulation over all these years and of this new amount being dumped into the Hudson River, that you're planning to dump into the Hudson River?
So just to correct the question, no one on this panel is discharging. This is a Holtec operation.
Understood.
So we-
But you're
so
that you're
we are not-
allowing
we-
Holtec.
We are not dumping, just to clarify.
You're allowing Holtec.
Okay,
They are
so
allowing Holtec.
NRC
And you're
can
compliant
take the
with
question
that.
on tritium.
This is Bruce Watson again from the NRC. At our last meeting, we discussed bioaccumulation, and it does not occur. We also provided the panel or the board with a health physics position paper a technical paper from the Independent Health Physics Society, which described the fact that tritium does not bioaccumulate, and it continues to dilute with whatever water it is in. And so the bioaccumulation does not occur. Thank you.
Thank you.
All right, next slide, please. We're going to move on to regulatory standards. The questioner here is Susan Van Dolson, and the questions are, during the June 15th DOB meeting, there was a question asked about cancer risk exposure to radionuclides from nuclear power facilities, and the NRC representative said it was 0.1% for all populations. Where did this number come from? The representative went on to affirm that this number pertains to all populations, including fetuses and pregnant women. It is critically important to understand the source and validity of this information, so I'm asking for proof that the regulations are based on all populations, including fetuses and pregnant women. The NRC commissioned a cancer study from the National Academy of Sciences. The phase 2 study was terminated due to cost. Termination of the study due to cost is very unfortunate. It creates a situation where the public doesn't have confidence that the regulations for radioactive releases from nuclear power facilities are based on the most protective possible standards. Would the NRC address this lack of confidence and provide more scientific basis for the current radioactive regulations that are being followed during decommissioning of Indian Point and other closed nuclear power facilities?
This one's for NRC.
Yes, thank you. This is Bruce Watson again, and as a matter of fact, I'm the person who made the statement.
I know, I remember.
That statement was based on the fact that our federal regulations, 10 CFR Part 20, are based on the International Council on Radiation Protection recommendations. In particular, they are based on ICRP 26, Report 26, and while some people may think it's dated, the information there has not changed significantly because the Commission has looked at those standards numerous times and determined that they are safe for the workers, the public, and the environment. So our standards are good. I also mentioned the 0.1% cancer rate risk in association with the fact that people living within the vicinity of a nuclear power plant are likely to receive less than 1 millirem per year from the plant operations or the plant being decommissioned. Now, our cancer risk in Part 20 is based on the ICRP risk of 1 times 10 to the minus 4 cancer risk for an exposure of 1 rem, which is 1,000 millirem. So if you're receiving 1 millirem a year, you can just do the math, 1 times 10 to the minus 4 times 10 to the minus 3 is well below 1.1% for anybody that lives in the vicinity of a nuclear power plant for attracting cancer. Unfortunately, about 30% of us will obtain, get cancer during our lifetimes, and about 20% of us will die from it. But I was just recently at a Health Physics Society meeting last week. There's a big study going on called the Million Person Study, which is looking at the doses to workers since, I guess I'll just say since the atomic age came into effect. It includes not only the NRC operational workers, occupational workers, but the Department of Energy, a whole host of different people, Navy nuclear people who have received exposures typically in excess of 10 rem. And their preliminary conclusions are that, there is no demonstrated association of radiation exposure, even at the 10 rem level, with cancer risk. Now, we just agree that, in principle, that there is a potential risk of having cancer from radiation exposure, but not certainly at the 1 millirem limit because, or 1 millirem exposure level in a year. I mean, in a year, we get 620 millirem per year just existing on the Earth. About 300 of that is from natural sources in our foods, from the Earth itself, and also from our man-made radioactivity, whether it's through medical or other means of getting exposure. So, less than 1 millirem and natural background being around 600 exposure for the year, it's pretty insignificant of the risk.
Well, I remember you saying all of this the last time, but you're still not proving to me that the first statement included all populations. You're saying workers and people who live there.
Well, okay.
Does that include the populations I listed in my question?
Well, okay, let me rephrase that. At the meeting, I did mention that the ICRP recommendations, which the NRC dose standards are based on, are reflective of all sexes, ages, and I forget all the other criteria, but it includes all the parameters and maintaining those safety standards at a reasonably safe level. I say safe level, and that's why our standards are well below a lot of the requirements in the ICRP.
Well, first of all, it's very old, the study you're talking about. And second of all, my second question goes to the trust factor or the distrust factor.
Okay, well, and I can't make you trust what I'm telling you.
Well, why did you cancel the cancer study?
Let me finish, please. You know, the policies of the NRC are determined by a presidential-appointed commission, and they set the policy for the NRC. They are the ones who approve the regulations that the staff provides. And so, over the years, the staff has evaluated the different changes in the cancer risks in the ICRP reports, and the commission has continuously looked at those, and in particular, we'll talk about in the next question, determined that they have not changed, that we would want to change the regulations. So they are the policy setters. This presidentially appointed commission makes sets the policy, and the staff follows their policies. And so that's why we have not changed since the regulations since 1990.
I can only tell you that the majority of Americans don't trust your organization, first of all. I don't care who's appointed there. They are not trustworthy.
Miss, we're going to move on, okay?
Can I move on to my second question that he didn't respond to? He didn't answer about the cancer study.
I was only responding to the first question.
The cancer study.
Yeah.
He didn't respond about the cancer study.
Also for the NRC.
First, he said they didn't know they
Okay,
had
we're
one,
gonna
and
give
now
him a
he
chance
said...
to respond, thank you.
I appreciate your passion and interest here, so let me try to answer the second question. So did we begin to look at the potential for a cancer study in 2010? Yes. We looked at some scoping and phasing of it. We worked on it for about 5 years. We got to 2015. We took the results we got in the NRC and we said, what do we do next? What is justified? And in 2015, we had a proposal in front of us to go look at 7 nuclear power plants, representative of different designs, et cetera. 7 being a small sample of about the 104 that were operating at the time. And we looked at that and we said, look, it's going to take us 3 years to do that next phase and $8 million. And the commission now, the presidential appointees looked at that and said, is that the best way to spend our, now wait, please, wait. Is that the best way to get bang for our buck for safety? And will we get usable results out of it? Will we have data that's definitive that we can use? Just like the ICRP report, and by the way, I have a copy here. Be happy to discuss it with you and get to drill down on it like you want to on special populations. The point is, we're using the best engineering and science we have available. And we're constantly, to Bruce's point, looking at ICRP and what they're learning, National Cancer Institute, the Health Physics and Radiation Protection Societies. We're always looking to understand more, okay? So we got to that point in 2015 and we said, what are we going to get out of this? And we even scoped and we said, well, look, seven plants is not a lot. What if we did all of them, right? And if we did all of them, it would have taken several more years and tens of millions of dollars. And we had to ask ourselves, we're going to get any definitive answers that would help us be a better regulator and improve safety. And we couldn't justify that we would.
I think it's very, very sad. I've had cancer. I'm sure if you ask these people in this room to raise their hand, a lot of us have had cancer. And I think it was worth $8 million. You say it takes X number of years to build any nuclear power plant. That doesn't deter you from wanting to build more of them. So time isn't really a problem if it's 3 years, in my opinion. For $8 million in the scope of what you're spending, I'm disgusted by that. I'm very sorry.
Miss, we're here to get some questions answered, so we're going to move on to the next topic. Again, regulatory standards. Okay, ma'am, please. The NRC license termination rule, LTR policy, has a radiological standard for unrestricted use of 25 millirems per year, which is based on a cancer risk of 1 in 500 people. This means the exposure to all remaining radioactive materials after remediation is estimated to result in 1 in 500 people contracting cancer. The EPA has stated in 1997 testimony, a 2000 letter, and a 2014 memorandum that the NRC LTR policy is not protective. EPA requires a risk range of 1 in a million to 1 in 10,000 cancer incidence risk. For instance, an EPA official stated the NRC policy would not adequately protect either the health of our citizens or our nation's natural resources. To put it bluntly, radiation should not be treated as a privileged pollutant. You and I should not be exposed to higher risk from radiation sites that we would be from sites which contain any other environmental pollutant. I would like to ask the NRC and EPA to explain why an unprotected standard is allowed to exist and why the public should be subject to this risk. Why the EPA, what will the EPA do to support a state-led approach to regulating waste from Indian Point so the New York State can require the NRC to use the risk range of 1 in a million cancer risk?
I think this is for NRC?
No, this is for
And
New York.
for EPA.
No, it's all state agencies, how are they going to rectify this inconsistency for cleanup requirements between all other industries, all other polluters, and nuclear waste?
Okay.
cleanup?
Let's start with the NRC and EPA, and then we'll move on from there.
NRC is not.
You good? Okay. Well, first of all, the license termination rule, I'm not sure where this 1 in 500 came from, but we looked for it, we couldn't find that citation anywhere.
Could I just add, because we researched these questions, there were citations provided in the questions, but those citations respectfully did not have the 1 in 500. We searched for the 1 in 500 that didn't exist in the citations that were provided.
It's
So if there
part of-
is, sorry.
Yeah,
if there
it is. It's part of the EPA testimony. There are letters from the EPA. I'm not saying Region 1 or Region 2. From the EPA, they have testified on this issue several times. They've
Yes.
written letters, and they have cited these
It
discrepancies.
says it right here, 1997 testimony, 2000.
Well, we obtained the testimony. The 1 in 500 figure specifically,
We'll look for that.
that would be good. Yeah, that's what I'm seeking.
Thomas Merrick had written to me, and I gave him the citation.
We have the citations. We look for the 1 in 500 in those citations.
One more time, and I'll find it.
Okay, but anyway, I'm sorry.
It's obviously not in the NRC termination rule because we looked. But moving on, we do use a cancer risk of 1 times 10 to the minus 4, which you quote in here. And so the NRC came up with the license termination rule and basically the release criteria for unrestricted use of a site, any licensed facility in the United States is going to be 25 milliroom plus the practice of Alera. And so the commission decided that was the limit they were going to use, or the criteria they were going to use with the practice of Alera. I'll just say almost all sites are significantly below the 25 milliroom. And as a matter of fact, we've terminated 12 nuclear power plants, and all of those have been terminated for only a few milliroom per year as a residual dose. And they have been all unrestricted release. In addition, we've also terminated the license at about 80 complex material sites, and they've all met that criteria, and of course, a small fraction of that limit. Now, in considering the 25 milliroom limit that plus the Alera that the commission published in our rule, the International Atomic Agency endorses a limit of 30 milliroom per year. The states, though, can mandate their own requirements and negotiate those with the licensee. In Massachusetts, they established a 10 milliroom limit for, I think it was Yankee Row. Also, Connecticut had another limit of, I think, 15 or 17 for Connecticut Yankee. And I think you have in your rule or your agreement.
Joint proposal.
Yeah, your joint proposal, I think it's 10 milliroom per year.
Correct.
So I'm, that's the NRC's response, I guess, to this question. We think that, we believe, because the commission has determined that's our policy, and that 25 milliroom for unrestricted, plus the practice of Alera, is adequate for unrestricted use. It takes into account that you may also get exposure from other places, because we do have the 100 milliroom per year limit. for the general public, and so it takes into account that that would be one small fraction of that limit, that 100 limit. So thank you.
The question was really directed actually to the EPA.
Okay, EPA's next.
Yes, hi, I'm Rick Ruvo. I'm the Air Director from EPA Region 2. And I understand, the question and your reference to EPA's 1 in a million cancer risk. But in this situation, EPA defers to NRC when it comes to radiation pollution. But recognizing that, we collaborate with NRC. We have a memorandum of understanding. We consult with them on the decommissioning plan. We'll continue to do that and encourage that we work towards the lower threshold that you're referring to in the question. So we really have nothing to add to NRC's response other than we will collaborate with them on the decommissioning.
Right, but that's not, I appreciate very much your responses, but that's really not answering the question that's being posed. The question that's being posed is that the cleanup standard, which is based on this very unacceptable cancer risk, is very different from the New York State. For example, New York State 2003 Brownfield Cleanup Program and State Superfund Statute. It's a very different cleanup standard, and the question is posed to state agencies, not to the NRC. It's posed to New York State agencies. How will you rectify this inconsistency? The cleanup standard is way different for these cleanup sites than it is for other industries. It's a pointed question to New York State.
Okay. Go ahead, John.
I'd like to just level set what we're talking about here. The NRC standard is 25 millirem. In the Indian Point joint proposal, the parties represented by folks around this table here, the Attorney General's office, the Department of Public Service, and others, negotiated a standard of 10. So it's less than half of what, it is more protective, let me say it that way, just so so that the transcript is clear. It is more protective than what the NRC standard is. So I understand your point. I understand your point for a desire for there to be a protective standard, and that is what state agencies negotiated here. That is what Holtec agreed to, and that is what the Public Service Commission ordered, and it is an enforceable condition here. So I understand the question. I understand the question going to NRC and EPA, but I'm telling you in this context that your New York State agencies negotiated and imposed a more protective standard, and that is in the public interest.
Right. It's appreciating that you said it's a more protective standard than the 25 millirem, but it is still inconsistent and much less than the 2003 Brownfield Cleanup Program and State Superfund Statute. And that's the question, is how will this inconsistency be rectified? It's a very serious inconsistency. I appreciate your answer, but it still doesn't answer the question. And furthermore, the consent order that DEC signed with Holtec is deeply flawed and it is completely unacceptable. And
I think
really,
we're going a little far afield here.
we are, but it's the same question.
Is there a further response to the question?
It's the same question over and over again, which hasn't been answered.
Okay, I'm asking if there's an additional response from the panel, or should we move on to further regulatory standard questions?
At risk of repeating what's been said, the state took action on our own that resulted in a more protective cleanup
A
standard.
more protective, but still
Then-
doesn't
then-
match up, so it's very different standard for different industry. And my question, and I believe Ms.
The question
Dolson's
has been
question
read into the record.
is that what are the state agencies doing to rectify that inconsistency? Not how it brought it up a bit, but how is it going to get these industries to align so that they have the same standards and don't get special treatment?
So as to special treatment, New York imposed 10 millirem, and I believe that no state in our union has imposed a more protective standard than the New York State agencies imposed in this case, that no state goes below 10 millirem. I'd be open to be corrected on that, but I believe other states are at 20 and 15 and numbers like that. I believe no state is better than New York, what New York has imposed here.
But it's still not meeting that same
Okay, we're going to move on to
remediation
the next question.
limit of
Later.
1 in a million
10 past 8.
cancer risk. Thank
We have
you.
a long way to go. Thank you. The regulatory standard, so we have additional questions coming from Joel Gingold, Michelle Lee, and Ellen Weininger. Holtec has never before completed the decommissioning of a nuclear plant, yet it is currently the contractor for several units. Until it has demonstrated that it can perform such decommissioning safely and efficiently, shouldn't Holtec be held to the highest regulatory standards with substantial oversight by the NRC? If so, why then has the NRC continuously relaxed the regulatory standard for decommissioning and granted a number of exceptions to the regulations to Holtec? Can the NRC elucidate how it applies the ALARA or ALARA principle? In doing so, can the agency explain the principle which guides such application, especially where radioactive releases would be deemed within regulatory standards? In other words, how does the NRC ensure principled application of the ALARA principle? What are the steps the New York Department of Health, the New York State DEC, and other New York State agencies are taking to exercise authority as an agreement state and as empowered by the state law to regulate pollutants? Please describe for each agency.
I'd like to answer the first bullet so you don't confuse it with answering all three at the same time. We agree that Holtec has not completed a decommissioning of a nuclear power plant, and they did apply for a license with the NRC, and we do a technical review of the company, and also their financial review, and we found that they were technically qualified to become a licensee and decommission the plant. I think the state may have probably done a similar review during their assessment of the application. So the second part of this is Holtec and any licensee is held to the highest standards that we can have, and those are the NRC regulations. And so there's no difference between a Holtec license holder being the whole license holder or any other company or utility being the license holder of a nuclear facility in the U.S. So everyone is treated the same. As far as continuously relaxing regulations, I think we've touched on this before at a number of different meetings, but the Part 50 regulations were intended for operating reactors. And so in 2014, the NRC put together a group of people to look at the regulations and make them provide the rulemaking for changing those regulations for those requirements on operating reactors that no longer apply to a plant when they're in decommissioning. That rulemaking has been evaluated. The proposed rulemaking was provided to the Commission about a little over a year ago, and we're due to provide the final rule on the decommissioning transition rulemaking, is what it's called, to the Commission in 2024. And what this rulemaking does is it eliminates most of the requirements that an operating plant does have to maintain, but does not have to do to maintain the decommissioning site in a safe configuration and being secure. So the NRC is taking those steps to codify those changes, and so we don't have to issue so many amendments and exemptions. And if you look at the 14 plants that have shut down since 2013, 2014 period, they've all made the same requests of the NRC, and they have been made, and these amendments and exemptions have been granted. Because of that, they're no longer applicable. Thank you. Talk about the Lara?
I'm just going to add a little bit on this. This is Paul Crone, NRC, what Bruce said, and then I'll hand it back to him for Alara. The thing about regulatory standards for decommissioning and relaxing, context for that, after you stop operating a reactor, after X number of years or months, it's just physics. It's the decay chain. It's how elements behave and isotopes behave. They go away, right? So when you look at things that can go wrong, less can go wrong. That is just reduced. They don't go away. It's reduced. So when you look at things that can go wrong, things that you need an emergency plan for, the risk decreases over time. So some of the exemptions you're talking about here are changes, when appropriate, after X period of time to things like the emergency program. And a site like Indian Point is no different in those exemptions than other plants across the country who, after X period of time, have done the same thing.
Thank you. John, do you want to add?
So as to what is the role of the state? I believe that's the third question here. As an agreement state, what actions has the state taken? The state, is facilitating transparency on Holtec license amendments and Holtec exemptions. These are posted on the DOB website for community review and transparency. And no, that is what we do. We post those and we review those carefully and we comment on them. And when there are concerns
Please stop the outbursts.
When there are concerns about what Holtec has proposed, various state agencies, whether it's the Department of Public Service or NYSERDA or the Attorney General's office or other agencies as appropriate, we weigh in on behalf of the state, we comment, we have opposed certain exemptions which we have discussed at prior meetings, and we have shared those initiatives and those efforts with the attendees at these meetings. And also, the NRC has mentioned the decommissioning rulemaking. The state agrees that the decommissioning rulemaking is ripe for updating. This state, for several years, has provided several detailed comments, suggestions, and commentary on that decommissioning rulemaking, and we have been very involved in that, and there have been multiple comments that have been submitted. So the state is, accessing the opportunities that are provided in the NRC regulatory space and presenting very detailed comments there. And it is made several objections, over the last many years.
Did the panel want to add anything to about the ALARA principle?
Yeah, we do.
Oh, NRC.
Yeah, I'll try to accelerate this too. Paul Crone again, to be brief on time. So Alara, here's the point. You have to be less than regulatory limits for sure, but you want to drive it as low as you reasonably can. So you're considering a number of factors. What's the best state of technology? Did something new come along? Can I drive it even lower? What if I have to take apart a pump and, because that's part of decommissioning, can I practice on a mock-up that's not in the plant to reduce my time in front of the pump when I take it apart? Those are things that are Alara. So you're driving as low as you can get in a reasonable manner, trying to optimize to the lowest exposure. And Bruce will give you one or two examples.
Yeah, the regulations are, in Part 20, provide a system for the limitations for workers and members of the public. As I said before, we do this through our licensing activities, we do it through our inspection activities, and so we're constantly looking for the ALARA principle to be used. In the U.S., the annual exposure limit for an occupational worker is 5,000 millirem. The average exposure to an occupational worker in the U.S. nuclear power plants is 120 millirem. That's practicing ALARA. using the best technology, using cameras where you don't have to go in and physically be in the room to get the exposure. And so even in the off-site dose calculation manual, there's a limit of 3 milliroom, and we practice ALARA. We try to get down to 1 milliroom or less for our effluent exposure. So ALARA is ingrained throughout the entire operation of these facilities, not only nuclear power plants, but also our material sites and uranium recovery, the fuel cycle facilities. And so you just do the best you can that's practical in practicing the ALARA principle. And it's outlined in the Part 20. So thank you.
Thank you. Now move on to questions related to dry cask storage.
Did you want to have a follow-up?
Yes,
Okay.
I came up, I had the third question
Okay.
related to the agreement state status of New York. And the question was pertaining very specifically to regulate the discharge and remediation of certain radiological materials for the protection of the public health and safety from radiation hazards, which includes byproduct materials such as tritium. So again, this goes back to discharge and goes back to New York State's authority, and actually goes back to what I said earlier about on-site and NRC's jurisdiction over the tanks and fuel pools, but it ends where the water reaches the Hudson River. So it's kind of connected here, and I was looking for an answer more
Sure, if I could
specifically,
jump
not
in
to
for
the
the agreement
comments,
state, I
but
can-
also to the very specific aspect of
The
discharge.
agreement state status
Sure, I can-
be
I can-
handled by Department of Health, Alex.
My name's Alex Damiani, I work with the State
Thank
Department of Health. So to address the agreement state, there's sometimes some misunderstanding over that. That is a delegation of authority from the federal government in some very specific situations to the state. There's about 40 agreement states. Most states are agreement states. One of the specific provisions that you may, if you've seen the agreement, it's posted on the NRC's website. You can find it relatively easily. One of the specific provisions in there is that it does exclude facilities that the NRC regulates, specifically nuclear power plants. So we don't get into this issue of like a dual licensure. They regulate it and we regulate it. A nuclear power plant is exclusively regulated by the NRC, and that includes their effluent releases. That is under their jurisdiction. If you go to Westchester Medical Center, that's our licensee, right? You go to, other commercial operations or medical or academic places in New York State, those will be state licensees. But the nuclear power plants and other, it's called exclusive federal jurisdictions, West Point, military bases, that sort of stuff, VAs, that'll be an NRC licensee. Excuse me.
Right, but we're talking about that juncture of, and I seem to recall this listed in the Part 380 materials when the draft regulations were coming up, and the agreement state was mentioned, and was mentioned also having to do with for the protection of public health and safety from radiation hazards, which includes byproduct materials. It's specifically byproduct materials. And again, going back to the statement that I made earlier about discharges, as an example, going into the Hudson River, again.
What is the question?
I'm asking about asserting the authority as it pertains to the discharges by utilizing the agreement state status, as well as taking into consideration all the things that happen, as I described earlier, with the circulating water system, the withdrawal of water from the Hudson River, which does not come under the authority of the NRC, comes under the authority of the state. And then what happens from there to then turn around and discharge it, because...
Okay, do we have a response? Is the question understood?
I can only speak to the agreement state status, not so much the water intake, if you will, but I would go back to the agreement state status, or the agreement would exclude any material that was licensed by the NRC. We would not be
Right.
regulating that.
Right, but that's not.
But if the
yeah.
NRC wants to concur or correct me here.
Yeah, my question is to the
So
state
I think,
agencies.
if I could weigh in, I think Alex has answered the first question. I think he's answered the second question, the follow-up question. And the federal statute that's applicable here, and which is the Atomic Energy Act of 1954, and carves out and reserves to the NRC the regulatory authority over such facilities and their operations. And that's the end, period, full stop.
And NRC?
Let me just clarify a couple things here. The agreement state status is an independent thing with each state, what they want to regulate. And they're authorized to regulate licenses under Part 30, which are medical, industrial. It depends on what the state wants to do. So the state of New York has a variety of these types of licenses they can administer the licenses for and regulate, inspect everything. But be very clear, these are called material licenses. They're not reactor licenses. The NRC is the licensee for all power reactors under Part 50, and non-power reactors for that matter too. But so the state of New York, and I don't want to say exactly what because I'm not familiar with it, but states are authorized to regulate material type sites under that we would regulate under Part 30. And those include industrial users, medical, as I said. So there is byproduct material associated with those licenses, and so the state has the authority to regulate those byproduct materials from those types of licenses. The NRC reserves the right to regulate the byproduct material from the reactors of Part 50 licenses. So does that kind of clarify it?
Yeah.
It's two different types of
Yeah,
licenses.
so just one quick follow-up.
Ellen, I apologize, but there were two other individuals that are on this slide, and they're
Right.
virtual, and they have follow-up questions to ask
Okay.
as well.
I just want to ask, who would issue the permit? Who? New York State or the NRC for all the Hudson River water that must be extracted to go through this circulatory system? Who would issue that? New York State or the NRC?
It's not a specific permit?
Again, the operation of the facility and its discharge operations are controlled under the Atomic Energy Act of 1954, and that is regulated by the Nuclear Regulatory Commission.
But that doesn't answer who authorizes
This
the
concerns
intake of
the
the
operation
Hudson River.
of this is part of the operation of the facility. There is an operating license that has been issued by the Nuclear Regulatory Commission. It pertains to the operation of the facility and the discharges, and that is regulated under the auspices of the Nuclear Regulatory Commission. And that is,
Out of fairness,
that is
sorry.
the answer.
Okay, out of fairness to other folks, we do have to move on.
Thank you very much.
Do we have other follow-up questions on this topic?
Yeah, there are two virtual
participants. Joel Gingold?
Yes, thank you. Can you hear me?
Yes.
Number one, thank you for this opportunity. Number two, I'm not really satisfied with the answer I got. If in fact the NRC is properly overseeing the site, why then was it necessary for the state to appoint a resident inspector? And why also has the state itself taken exception to a number of your exemptions? I would point out to the NRC reps that back in the 1960s, I believe it was, when I was a young engineer, I was responsible for the licensing of what became the Donald Cook plant in Michigan. I spent a number of hours sitting across the table from the NRC staff. And I can assure you it was not a pleasant experience.
Sir, we're going to try to get answers to the questions that you posed. So if the panel is prepared to answer the questions that were asked, please.
First, Joel, thanks for the question. I too have walked DC Cook many times, so we share a common experience. On the NRC inspector side, and your comment about the New York State inspector, as you knew, we had resident inspectors. I'm sure you've met them at sites before. We still send decommissioning inspectors in multiple areas of expertise up to the site several times per quarter. Our last public inspection report that documents that was issued March 13th. Do we stay in touch with the site so we understand their work schedule and activities? Absolutely. Very, very frequently we get updated schedules. We know exactly when evolutions are going to occur, and we're on site when we need to be to watch something. So hopefully that helps. I don't want you to think that we don't have presence on site. We very, very much do.
I was going to say
I think Michelle Lee has a follow-up as well.
Go ahead, Ms. Lee.
Hi there, can you hear me?
Yes.
Okay, so my question did not really get answered. I had asked how the NRC ensures principled application of the ALARA principle. So referring to one of the standards and saying about the standard is not saying how you ensure principled application of it. And I appreciate the rhetorical commitment, but the quote, do the best you can is practical, does not, it's not really explanatory. And frankly, what you're saying is you just do a sort of ad hoc, you know, when we can, we'll try to do it as much as possible, depending on how much money the licensees want to spend on it in any given day. That you should be candid with the public and acknowledge that and not go on and on about it.
Okay, we're going to try to answer that question. Panel, please.
Paul Crone, NRC, and Tony, I'm going to ask you to provide some perspective here in a second. So I hear what you're talking about, Michelle, in terms of principal application. Before I turn it over to Tony, we go out and we inspect how a licensee applies ALARA. In other words, we'll look at a specific job and we'll say, okay, you got 100 millirem for that job, but we will look at it in the lens of you could have done better, your techniques could have been better, it could have been a quarter of that, it could have been 25. That type of thought process is written into our inspection procedures. It's what we look for, and in cases where a licensee does a poor job and could have done better, that you'll see it written up in our inspection reports as a violation. So that, and Tony, I'll turn it over to you, but yes, we look at it in how it's physically applied.
Thank you, Paul. Tony Dimitriadis, NRC. I apologize for my voice. The ALARA principle is something that's taken to try to reduce a dose below a regulatory limit. Bruce indicated earlier that there is, the ICRP talks about a 10 rem dose limit that it was studied on, and the evidence associated with cancer risks below 10 rem, which is 10,000 millirem, is inconclusive. So let me just start there. The occupational dose limit is 5 rem, 5,000 millirem. Licensees impose an administrative limit of 4 rem, 4,000 millirem, and they're allowed to, they can have their workers get a dose up to 4 rem if they wanted to. They don't do that. They actually impose individual jobs with an estimated dose for a given job, like Paul indicated, working a pump, a valve, or something like that. And they estimate what that dose is based on experience. And when they do that, they say, well, we think this job is going to take about 200 millirem. And then they take that, excuse me, they take that and they say, well, what engineering standards or techniques can we do to reduce that from 200 millirem to, let's say, 100 or 120? And as Bruce indicated, an average dose to an occupational member that means somebody who works at the plant, has gotten an average of about 120 millirem. That is a direct result of applying the ALARA principles. That means taking engineering analyses alternative methods, technologies like cameras and things like that, so that they can protect their members of their workforce. I hope that answers your question.
I'll just try and kind of wrap it in a bow. As I said, the regulations require the practice of ALERA. The licensees do that through procedures on how to do work in evaluating the jobs that need to be done, and they look at how they can reduce the dose, whether it's using, as the classic examples, are time, distance, and shielding. In more recent years, they've looked at better technologies, using cameras, using remote tooling, and other applications to reduce the dose. As I said before, the average dose to the average worker in a nuclear power plant is only about 120 millirem per year. And that's well below the administrative limit, or the regulatory limit. And so the licensees do practice having administrative limits as targets to make sure they don't exceed any regulatory limits. Second thing I want to mention is that the industry, including the operating plants and the ones in decommissioning, are expected to take into account lessons learned from each other. On May 2nd of this year, we hosted a lessons learned workshop. It was publicly announced and available for people to listen in on, but we invited all the licensees from the decommissioning plants to come in, and they spent 4 hours going over lessons learned that they have come up with in the dismantling and decommissioning of their plants. And this included the Indian Point representation and other plants that Holtec and other plants, I don't want to make an infomercial, but all the key players were there, Energy Solutions and the other ADP were all there representing and provided information on lessons learned, not only for radiation exposure, but also that industrial safety issues where they've learned to do things safer and better. So I'll conclude it with that. Thank you.
Thank you.
Thank you. The next topic is dry cask storage. The questioner is Susan Shapiro. How long did it take the NRC to approve Holtec spent fuel casks being used at Indian Point? Have any of Holtec spent fuel casks leaked at Indian Point or any other site? What is the projected rate of leakage or damage of the spent fuel casks? And are radioactive releases from the spent fuel casks monitored, and if so, how?
Okay, thanks. Paul Crone with the NRC. How long did it take to approve the spent fuel cask design? About a year. That's something Bruce mentioned before. Again, those results are available publicly, something called the Safety Evaluation Report. Have any of Holtec spent fuel casks leaked? The answer is no. None that I know of. And that goes to the next question. What is the projected rate of leakage? The answer is 0. These are seal welded shut. There are no openings on these casks. Picture, if you will, a big metal cylinder, several feet tall, several feet wide, welded shut, with helium inert gas inside. So that's what they are physically, surrounded by shielding.
Paul, can you speak into the mic? This is Tom Kazmir.
Oh, I'm sorry. All right. Thanks for that, Tom. So let me go back to make sure everybody hears. How long did it take? About a year. The results and specifics you can find in the Safety Evaluation Report on the Holtec casks. That is publicly available. Have any casks leaked? The answer is no. Have they leaked at Indian Point or any other site? The answer is no. And then I had gotten to say, look, these configurations, these are welded shut. Stainless steel, tall cylinders, several feet tall, several feet wide, with a lid at the top that's seal welded shut. What's the projected rate of leakage? They are sealed, so the leakage rate is 0. They have aging management programs, et cetera, inspections that we do on them, monitoring by the licensee, which goes to your fourth question. Are the releases monitored? Yes. There are monitors around what we call the ISFA-C pad that would measure anything that might potentially come out of the cask, but we've never seen that.
Okay,
Mr.
follow.
Shapiro, I'm just going to remind you, the next slide is all your questions too
I
on
know.
dry cask storage, so if you could just keep your follow-up to these
I will, very
specific
short.
issues.
Okay.
Thank you.
I believe that at San Onofre there was a leak, so I don't believe that's correct. And there was at least damage to the cask. My question is, what's the corrosion rate of the casks? They're made out of thin stainless steel. You must have a corrosion rate calculation. What's the corrosion rate?
First of all, there was no leak at San Onofre. There was a case where they, when they were lowering one of the canisters into the shielded vault they go into, it rubbed against the edge, and there's been extensive information on that. It basically was not even a scrape, but a blemish on the outside of the cast. It was not really damaged at all. There are ongoing studies on EPRI for aging management that are conducted by the Electric Power Research Institute. And I'm trying to remember what else we were talking about.
Are those available to the public, the EPRI studies?
The EPRI information, well, actually, the inspection results from San Onofre would be in the inspection results that were issued by Region 4.
No, you just
So-
referenced
so-
EPRI studies. If you
Well,
could provide that to the public.
Let me answer the question. The first part of the question was about San Onofre. San Onofre, like I said, the inspection reports are publicly available, as are all NRC inspection reports, unless they're pertaining to security, are available on the NRC website or in Adams. And so EPRI, though, does publish materials. They are a private entity, and so I don't know the availability of their reports.
$80,000 a year
Well,
to be able
well, I
to
just
get
said
a
they're-
copy of their reports.
Well,
that
that's-
you're relying on. So if you're relying on, could you please provide it to New York State and to the public? If you're relying on these reports, I ask that you provide them.
They are used in our formulation of regulations and inspection requirements, and I can't speak to that issue because I'm not knowledgeable in them. But they are a private entity, and their research is their research material, and they choose to share it with us as they see fit. And, but they do collaborate with us on a number of aging management issues, because we also do aging management studies in our Office of Research. So thank you.
Thank you for relying on studies that no one could see but yourselves.
Okay, we're going to move on to your next set of questions related to dry cask storage. Are the spent fuel casks vented? If so, is the venting monitored for radionuclides? If not, why not? Please provide all monitoring data. What plan does the NRC have in the event one of the spent fuel tanks leaks or needs to be replaced to prevent the unplanned release of radionuclides? What chemicals and radioisotopes are present in the spent fuel casks? And what plans does the NRC have to fund replacement or repairs of spent fuel casks if needed? In the event replacement or repair of the spent fuel casks are required, who's responsible for the cost?
Okay, so first question, are the spent fuel casks vented? The answer is no. I told you they were just seal welded, right? So they're sealed shut. There's no vent on them. What plan does the NRC have in the event of a spent fuel tank or cask leak? When you look at that safety evaluation report on that design, that includes a procedure whereby the licensee would take a cask, if it had an issue, back into the refueling building spent fuel pool and to be able to do any sort of operation on it. So you have to have a procedure, and you can find that in the safety evaluation report, to deal with an issue with the cask. Or go to a different cask design. What chemicals and radioisotopes are present? Same as in a reactor after time of decay, right? Fission products from the normal process, they decay over time and get reduced in quantity. So there's no difference. You have to look at a isotopic chart, but really it comes from operation. What plans does the NRC have to fund replacement or repairs if needed? That is the licensee's responsibility. If any repairs were needed, we would be very, very closely involved and informed right away. But that cost goes to the licensee.
Okay, how many years are the casks licensed for? My understanding is that they have to be replaced in a certain amount of time per NRC regulations. How many years is that?
I believe it's currently 60? Yeah, go ahead.
20 years.
I believe the casks are licensed in 20-year increments.
Correct.
The design lifetime is 80 to 100 years. And so with aging management, following of those from an aging management issue and ensuring that they maintain their integrity, I have no idea how long they'll last, but probably well beyond 100 years.
Okay, so
if
say
they
in
have to
20
be-
years, I want to ask you a question. Say in 20 years, these need to be replaced. You've already released the site from decommissioning and let Holtec take all of our decommissioning funds. Who's responsible for paying for that
Well, there's
replacement? And let me finish my question. And you said previously that you need, if there was a replacement needed, or if there was a damage, it would have to go into a spent fuel pool. Are you requiring that there remain an active spent fuel pool hot cell that can be used in the event this occurs, which we know it will occur because they're only licensed for 20 years?
Let me
Or maybe 100 years.
Let me revise the previous statement. If the dry fuel storage was in its own standalone system, so to speak, a structure, without a spent fuel pool, there are means of handling those types of potentially leaking casks by putting them in additional enclosures and casks and shielding them until they can weld shut another cask over them.
And who's responsible for paying for that?
Right now, the licensee would be responsible for paying those, but that would be reimbursable from the Department of Energy because they maintain the responsibility for disposing of those casks. So this is, the licensee is also required to maintain a spent fuel management fund for the maintenance and security of these facilities during the duration of them. And so there is a separate fund for spent fuel management that's maintained by the licensee and reported periodically to the NRC, and I assume the state, on what the status of that fund is to ensure that there's reasonably adequate funding to make sure that the safe is maintained safe and secure. I'm trying to think of what else I had needed to add to this, but there was something else in your question, but I'll, quite a few of them in a row. So basically the licensee would be responsible for ensuring the safety of the casks with our oversight, the NRC's oversight, and we would do that through our, making sure things are done through the inspection process. These casks, or the FCCs are inspected on a periodic basis. If there was issues, they would obviously have to notify us. We would get engaged with them, ensure they came up with a process for ensuring that the fuel remains safe. And of course, the responsibility for the immediate cost of those repairs or conditions would be with the licensee, and then would be reimbursable by the Department of Energy, who has ultimate responsibility for accepting the ownership of the fuel.
As a taxpayer of New York State, my question has to do with after you release this site from Holtec, and you say decommissioning's done, and then there's a problem, who's paying for it?
Well, the licensee is, there's still a license for the dry fuel storage facility. And so it reminds it. Yeah. It's a separate entity from the Decommissioning Trust Fund. And so it's remains with an independent trustee, typically a bank, and that trustee can only use that money for specific reasons. In this case, it would be for spent fuel management.
What percentage of the decommissioning funds are being put into that?
It's a separate fund.
Okay, we have two more dry cask storage questions, also from Ms. Shapiro. Is the federal government responsible for monitoring and storing nuclear waste? If not, who is? Is the host state, New York, responsible for the cost of long-term management of nuclear waste within the state? In the event long-term repository has not been approved before Holtec completes decommissioning of Indian Point, will Holtec be permitted to take the funds remaining after decommissioning if nuclear waste remains at the Indian Point site?
Okay, so the licensee, Holtec, has responsibility for monitoring and storing the nuclear waste on site under the Part 50 license. We've talked about that several times, right? Now, as a matter of national policy, we all know the word Yucca Mountain, right? The government is still debating where and if, I think, there will be a final repository for the country. That is yet to be decided and is a political matter. More to come on that, but I would say that that's under legislative, it's a legislative topic, not an NRC topic.
Are the casks approved at being used by Holtec at Indian Point able to be transported? Are they designed to be transport casks?
With an overpass.
Are they licensed as transport casks?
In the current state, just standing up, no. Tony can talk to you about other things separately, about extra packaging you have to have if you're going to transport it. But in a current state, just standing up on the pad now, no.
No, transport packs have not been approved yet, have they?
They have been, but the casks that are there now are not authorized to be.
Tony, I'm sorry, could you take the mic, please?
Yeah, thanks, Tony. That would help.
The casks that are at Indian Point currently storing the nuclear waste are not authorized to transport that across the country to some final resting place. there are casks that have a certificate of compliance for transportation, but that's not what they're stored there for. That's number one. Number two, back to the thin-walled casks that you mentioned, I think there's a misconception out there. The casks are thin-walled, but that's not all that there is. They are part of a whole system that are embedded inside an overpack that is composed of 2.5 feet of concrete and steel, and therefore they're very, very robust, very robust. I can't stress that enough. So I think there's a misconception that you've been fed. There is an element of it. That's like saying my car bumper is very thin, but that's not the end of the story. Your protection system is composed of a whole system, including airbags and ABS and safety restraint systems. Similar to that concept, the casks are part of a whole system, and they're very, very thick and robust.
Okay, we're going to move, we have very limited time left, so we're going to move to biological and health studies. Questioner again is Ms. Shapiro. Please provide reports supporting how the protective standard was determined. In 2010, the NRC contracted the National Academy of Sciences to perform such a study. Analysis of cancer risk nuclear facilities, phase 2, pilot planning. And there's a citation, page 3. Why did this health study commence? Why didn't it commence?
I think they answered these questions previously, so I don't want to waste time with that.
That's good. Thank you.
But I do want to ask the question to New York State and to the New York State agencies, how can you rely on the NRC's outdated studies, and what they're telling you is, well, it was going to take a little too much time to do health studies, so now you guys all have to trust us that something that was done from the 70s data that was not done by actual epidemiological study, which we now have today. We've had nuclear reactors for many years around the country, here at Indian Point. We now have epidemiological studies. They're relying on hypothetical projections from the 1970s. I'm asking New York State agencies, how can you put us, New York State residents, at risk based on reliance on these outdated studies when in fact health studies do not exist?
Okay, we'll try to get you an answer.
So I would only reiterate something that was stated earlier about the JP obtaining the 10 millirem standard that's enforceable under the commission order. But if DOH or AG's office wants to add anything.
I would say with respect to health studies, you're right, there are a lot of good recent epidemiology studies on radiation, but I'm not sure.
I can't hear you, I'm sorry.
I'm sorry, okay, I'm sorry. There are a lot of more recent epidemiological studies on radiation, but I'm not sure specifically what you're getting to studies on nuclear power plants, or what types of epidemiological studies are you referencing?
Okay, we're dealing here with tritium releases. We're dealing here with krypton-85 releases that aren't necessarily health studies. Some of my other questions dealt with climate change issues. There are strontium-90, which you're going to allow them to release before you even have the data of what's in the effluent. There's all these radiological studies that, yes, there are good epidemiological studies, but instead, New York State is bowing down and saying, no, we are going to let the NRC use their 1970s studies, and we're not going to protect our people, or our waters, or our biota, or our endangered species, because we're relying on the 1970s idea that the NRC had to promote nuclear as it's okay, but it was just hypothetical. And today we have epidemiological data. And instead of using that data, you're letting the NRC dictate to New York State our health. And I'm asking you why you're letting that happen.
I would add to my earlier statement, this DOB had requested an options analysis to look at not what option is available for the tritium that would meet a standard. Your concern is is the standard protective or isn't it, right? And to inform the discussion, we asked our independent technical expert to present a relative risk assessment of the options. Again, not to see which option meets the standard. It's assumed that all would meet the standard. But his analysis was what option is the best from a relative risk standpoint. And that presentation is available on our DOB website. It was presented by Dave Lockbaum. But from the state agencies that run the DOB, the request of him was, what's the relative risk of the options, not what option meets the standard. So we weren't even talking about what goes into the standard. And furthermore, no one is talking about discharging even close to the standard, right? And so the historical data show, and the monitoring in the river shows that the historical levels have been extremely small relative to the standard. And so from the state's perspective, that's what information we asked for to be presented, that's been presented. Obviously, more work and more discussion is ongoing, but that's what we've done to date.
But that's the final, on the site, the 10 millirems. We're talking about releases into the river. You're not using that 10 standard in the river. Those are releases, and so it's totally different things. Okay, so I'm talking about that. I'm talking about the releases that we're discussing here.
Yeah,
That
correct.
they're-
So was I.
Okay.
So my first part of the answer was the 10 millirem, which is what is the state doing that's different than the NRC 10 millirem? The other question was, are you okay with their standard on the discharge? And I told you what we've done as a DOB to inform that discussion. And what went into that was not, will the discharge options or the handling of the tritium options meet an NRC standard that you're calling into question? It was, what are the relative risks of the various options? And that was discussed. And the historical data was also reviewed on the water discharges themselves that have been going on now for some time. And that was compared to the standards and shown to be a very small fraction of the allowable limit. So when you're framing the
allowable limit the NRC's giving you.
Correct, but the discussion around this has been, suggestive that the discharges will be at the standard which you're calling into question as unprotective. And I would just point out that factual discussions that we've tried to facilitate here have been around what has the historical evidence shown, and that has been historical, shown to be a small fraction of the limit that you're calling into question.
With all due respect to David Lockbaum, he's an engineer. He's not a health physicist. You don't have a health physicist looking at this. That's what we're asking for. We're asking for health experts to look at this, not just engineers. That's the difference. So that's really what we're talking about here. And we do know that there's already contamination in the river. That's a PSC problem, because the PSC has, well, it comes to one of my later questions, but I'll bring it up now so we don't have to deal with it later.
Please.
The PSC has on the table still desalination for Rockland County, which is 3 miles south of Indian Point.
No.
Don't let her
Yes, it is on the
let her finish
table.
out.
It's as an option in case it is, John, I've read it. I've been participating in it. It's as an option if Rockland County still needs more water. The PSC can't say yes on both sides. They can't say it's okay to discharge, and it's okay that later at some point in time, after it's bioaccumulated into the silt in the Hudson River, that we're going to desalinate the Hudson River for drinking water for Rockland County. You can't say yes to both. You have to say no to both, or at least no to one.
Yeah.
It's really hypocritical.
Right. To be clear, speaking for the PSC, and I'm the executive deputy of the Department of
know.
Public Service, there is no desalination plan on the table.
It's still on the table. In your order, which got rid of the desal that's costing $54 million for Rockland County.
Our order explains that the provider of water has to always have sufficient supply. Whatever the supplies are have to meet DOH standards. And to date, they have not put desalination back on the table.
But they can.
They did have it. There's also.
You left the door open. We're
There's
asking you
always
to
going to
shut the
be
door.
the door open to any water supply option that the utility is required to then present, and that would have to go through a full permitting, just like their original proposal did. So it's not something that the PSC is saying, we want desalination plant. That's like a misrepresentation of what
You
we
need
said.
to shut the door on it.
Any water utility has to have evidence that they have sufficient supplies, whatever those supplies are. Then they would propose those supplies for valid permits. They would need DOH approval, they would need PSC approval for the cost recovery associated with that supply. And I want to speak to something else. With respect to the testing that they were doing when desalination was their proposal for supply, they did take water samples, and I have heard a number of comments about things that they found. I asked our staff to go back to verify what was found, because it was suggested that there were levels found that were of concern. There were non-detects on the vast majority of radionuclides they looked for, non-detects. And what they did find, I think there was one hit that was way below the regulatory limit for drinking water standards. So the evidence that they documented on the water testing is not as it has been portrayed, that they found radionuclides in the water that was going to make it a risk for the drinking water supply. What they documented in their sampling was I believe one hit, I can't remember which radionuclide, that was way below the drinking water quality standard. All others were non-detect.
Okay, we're currently at 9 o'clock.
And if you have, Susan, if you have evidence to the contrary on that, because you've been one of the folks who have cited it, I'm all open to seeing what evidence you have on any findings of concern in their water testing.
Okay, I'll
Thank
share
you.
that with you. The last question was, will Holtec be permitted to take funds remaining from the decommissioning fund if nuclear waste remains at the site at Indian Point?
I believe that we answered that. They have a separate fund for spent fuel management.
You want to
Yeah.
just, yeah. And the two cannot
No.
be commingled?
So-
One cannot take funds from one
Yeah.
and put in the
They may be
other?
in the same fund, but they're designated by the trustee as separate.
So how much is in that fund?
The latest decommissioning trust fund report is available on the DOB website.
You're talking about two different things. You're saying the decommissioning trust fund and then the
Does
spent
it
fuel
account
fund.
for both?
How much is in the spent fuel fund is what I'm asking.
In March, the company, Holtec, provided a public report. It's on the NRC Adams website, available for all. It's also available on the DOB website. I can't tell you tonight the exact amount that is in that, but I could readily tell you that by tomorrow. The decommissioning trust, let me back up. So during the license transfer process, Holtec and Entergy sought an exemption from the NRC regulation that requires decommissioning trust funds to be used for decommissioning purposes. And the state agencies vigorously opposed that exemption request. Nevertheless,
It was granted.
despite substantial efforts by the people at this table to oppose that waiver, the NRC staff and the NRC commissioners granted that. So there is a possibility, given that waiver, that decommissioning trust funds could be used for spent fuel management purposes. Nevertheless, and despite having been called a propagandist, a shill, one-sided, captured, terms that I reject, in the state proceeding, again, the people around this table up here on behalf of the public, negotiated minimum trust balances and also the possibility of replenishment from recoveries in the federal claims court for breach of contract claims against the Department of Energy, against the Department of Justice, and against the United States for breach of statute and breach of contract. So when folks say, oh, you're doing nothing, or you don't care, or you're not protecting the state, I would suggest respectfully that the folks up here on this table are doing everything they can to advance the public interest of New York State. And despite having the waiver granted, the dedicated public servants up here found a way to provide additional assurance for the Decommissioning Trust Fund. So I think there's been some discussion here tonight. I think it was important for me to clarify about the 2020 waiver that we opposed and the steps that the various New York State agencies took to protect the financial integrity of the Decommissioning Trust.
That's appreciated, very appreciated. My question is, can they still go into the fund for the spent fuel?
The question, well, there's an NRC waiver that was granted. There is also a replenishment or refunding aspect that the state of New York negotiated after the waiver. After the waiver was granted by the federal regulator, the state took additional steps to protect the financial well-being of the decommissioning trust. And, the record is clear on that. Your question at the end is really sort of speculation. What will happen at the end of the decommissioning process? I can't, we'll have to take that year by year.
Can the NRC, as they're doing now, say federal preemption? The state doesn't matter that they've created this thing. We get to preempt. We're the federal government. We're just going to ignore what the state did. And, we appreciate what you did, but it seems to me like they've already granted the waiver, and then afterwards the state tried to protect us, but I'm not sure how.
We did with an enforceable order of the Public Service Commission.
But the NRC is saying they preempt us, the state.
Not on this, on this
depends.
issue. The licensee voluntarily entered a joint proposal that was so ordered by the Public Service Commission and is enforceable.
Okay.
All right, we unfortunately have reached the end of time here. Before we reach the end of the questions, it's now 9:05. So I want to thank everyone for their patience, and appreciate the panel and the public for participating, and particularly our hosts here at the Town Hall.
Thank you, Tony, and thank you to our guest panelists. Really appreciate your time and effort. And thank you to the audience. We're adjourned.